Ask for that file.
Yes, everything is. I've seen that. The file is also here. There's nothing, no difficulty in showing it to your lordship, and we'll do that. And firstly, I am also satisfied that the process has been. Lordship also look into that. No difficulty.
Absolutely, that's
We'll that. But I thought let the hearing conclude, and then we'll try and look into it. Let the flow of thoughts.
You don't mind giving it to us?
No. I can immediately give it to Lordship. No difficulty.
You know that there will be nothing in it. We wanted to see.
In fact, I brought copies for all the honorable judges.
Fine.
That's it. I only thought that for getting into that,
no difficulty.
Yeah.
See, once we receive the matter,
there always be room for a little starry debate and.
The man was to superannuate at the end of December.
Yeah. The original file also is there. There's a original file also.
This one.
It's a copy of the original. All the relevant files. Whatever relevant, I put it together. And I've also put a note.
If you don't mind, just give us the original file because.
Yes, sir. Yes. I put a note on top of that. You don't see that. It just gives a.
The first page is the Attorney General's.
That's right.
Note.
My note.
It is not the part of the.
No.
Very well.
It's just how you look at it. It's a.
In the Attorney General's note, para 6, last line, Your Lordship's made.
I mean, I suppose there'll be a room for a small, very small, narrow debate. We are not here on a mini trial on this here today.
No, I'm not
Yes, please.
challenging.
Yes.
Not remotely challenging. Let me.
So what we find, we can just straight away put to you at page 4, at present, the Chief Election Commissioner, so.
Page 4.
That's right. You got it? According to the database of IAS officers serving and retired.
Yes.
In the pursuit secretary to the government has been assessed on the basis of the database maintained. I would like to suggest a name of 4 names for the consideration of the minister. So and so, 1985. They are not taking.
That is how it has always been done.
No.
I'm sorry.
I'm sorry. So, this is done by the Minister of Law and Justice.
That's right.
So he picks up the names. Okay. From the panel of 4 names for consideration, so and so, 1983 batch, then somebody from again 83 batch,
that is
and 85.
So regardless of the batch, what happens?
We'll come back to it.
Anyway.
We have got enough material. More
Yes.
tell you. This is put up on 1811.
Yes,
Correct? You find that the file moves on the same day.
yes,
And so first it goes to the minister,
yes,
then I don't know the name
yes.
of some officer. Then it goes to the hands of yet another person, fairly senior man from the name, again on 1811.
Yes,
Then the Prime Minister says, considering experience, profile, suitability, I recommend the name on the same day. So this is, we want not for any kind of confrontation, little sort of, is it done with such
No.
haste,
No.
if I may use the word?
no, not
With any
not
kind of,
because I've
but
examined.
the daring urgency that that all of this is done, and you require some time to contemplate.
That impression, Evini, I think your lordship will not have.
No. What
I've
I'm
looked
saying is,
into.
I can only tell you something. That is a personal experience.
Please do.
If you go to any office,
Please do.
any government office, usually somebody at the bottom of the pyramid will say, so it travels up to the top of the pyramid and then they're approved. One way of bureaucratic how it functions. I have personal experience. It happened in one case of mine. So ultimately, it said, can we do it? The question went to the bottom of the pyramid. Yes, it can be done. That is
Right.
So we are just tackling this issue.
I just wanted to say something. I certainly know that.
Otherwise, we'll be insincere to you. If we don't tell you what is in our mind, we'll be untruthful to you.
Would I have not asked the same question myself?
We just come to you. Now we see the man.
One thing I like to hear.
Your lordship, please.
According to your first page,
Fourth page.
no, not your note.
My note.
This vacancy became available on 15th of May. This vacancy
Yes.
became available on 15th of May.
Yes.
Can you show us that from May to November 18th, in such an interregnum period, what was that prevailed upon the government to initiate the process in a manner that is everything is to be done within a shortest possible time in
May I respond
a super fast
May I respond?
mechanism?
May I respond? I'll definitely respond.
You want something?
I have now. What is the process
know
we are
it.
looking at?
We know
What is the process we are looking at?
AG,
Is it
You
comparable?
know, where there's a will, there's a way.
Yeah.
There's a will, there's a way.
Yes.
But at the same time,
And the notification is brought on the same.
the same day process, the same day clearance,
1 minute.
the same day application,
Yes.
the same day acceptance, and the same day appointment.
Very well. Now, what should be done? It should
Not
before
even-
before you open up.
Attorney.
So I ask myself.
Attorney. Not even in 24 hours,
Therefore,
the file has not traveled.
therefore, the logic.
File has not traveled even 24 hours. As if
Yeah, very
the
well.
lightning speed is there.
Therefore, the
What kind of evaluation is
let
there?
me ask myself a question.
Yes. Please
I have
question
seen.
yourself.
If your lordships were to go, please hold your mouth. If your lordships were to go into question, I must produce all those instances of appointment from 2015 onwards. So every time the matter is moved within a matter of 2 to 3 days, maximum 3 days time. I can show all those files. There is no doubt whatsoever in how the speed, if
Attorney,
the speed is not there,
one thing.
then you say the court,
Attorney,
I just want to clarify some
One
basic
thing.
points.
Sometimes it is possible because of paucity of time, vacancy may lapse, officer may leave. There is some requirement. Sometimes we also move
Yes.
at very fast speed.
Right.
Fairly good. Nothing wrong in it. Merely because it's a faster mode, absolutely no problem. We are not in that. But the question is, we are asking you from 15th May 22, this vacancy was there. Can you show us that after, and you have recorded in this order,
In
that court has already taken note of the matter. Matter is now sub judice,
that I must
taken care of, and since there is no stay granted by the court, that's why there is no hindrance. This is you have noted.
There I must respond to that.
The appointment this evening.
Let me ask a question. I'm asking a question. These are concerns which normally will come to the mind of anybody. Why is it happening so great speed? There are how many instances of appointments in public positions happen within 24 hours? Happen within 12 hours? Therefore, are we finding a fault? I'm so sorry.
It's not there. You're right. There may be tearing hurry. You can't keep deciding it on the basis of. But the point is there is a context. We are considering.
I'll tell you. There I want to respond to that. I want to respond.
Number two, we are again coming back to the manner in which we are really concerned with the structure. See, the whole thing is, we come to page 4 again. We are requesting you to come to page 4. They say on the basis of the database maintained by the Department of Personnel.
Yeah.
And what is it? TPNT, I think.
Department of Personal Training.
Personal training, yes. I would like to suggest a panel of 4 names for consideration. Now, from the vast reservoir of officers, senior officers that you have, what is the criteria? How do you select? If you don't enlighten, we will not be getting anywhere.
So, sir.
See, supposing it is like this, you toss a coin, okay, that you win. If both sides is heads, the person who says heads, you win. If you are going to, what you are trying to say is, we are being very blunt. If, for example, if it is carefully chosen, all these 4 persons are chosen from persons who are, again, we may just borrow the yes man kind of thing. If you don't give room for people who may be, we are just concerned with the process of selection, Attorney General. We are not speaking about the individuals or anything. We have nothing against any one of them. In fact, we must also fairly notice that this person selected is a gold medalist in mathematics at the stage of A, my favorite subject. Again, gold medalist, he's a brilliant academic record he has. But we told you, it is not just being brilliant. That's the calling, that's the need for the particular post. The question is, you may have a man, we are not saying this about him, that he's excellent in terms of academics. But he's docile.
I mean, how do
most important?
I ask myself a question. Is therefore a lens by which either the executive says he is a docile person, he is a loyalty vote person. Somebody else will say, no, he is not a docile person, he is no loyalty vote. Which is the lens which the court will look into?
Yes.
I mean, which lens will look into? There is no litmus test. There is no litmus test by which you will say, some yes man is hiding somewhere, a lurking one, I'll pick him up and therefore hold him on to this. I think that can do.
Okay, now you tell us, how did the law minister pick up these 4 names from the database?
I tell you, then the bad seniority. That's why we have explained. Your lordships have seen the yesterday's note. Yesterday's note.
The reason is that it is from this 4, admittedly, the Prime Minister has finally recommended 1 name.
Yes.
So he gets to see these names. The law minister prepares a panel, as it were, and that is a field of choice from which you select somebody. Correct? This is a procedure. Now,
your lordship, sir.
Let's see the
Right.
Now, if you come to the actual selection of this man,
can I intervene for a minute?
Just a moment.
I will very humbly make an appeal to the court.
One more thing, and then we leave it.
Your lordship.
The field is yours. In the note can we take the name of the officer if you have no objection? Because I think it should be not the other person who recommended. We will not take so and so. That is a present incumbent appointee who is to superannuate in the month of December 2022 and has taken voluntary retirement. He is the youngest of the 4 persons on the panel. Considering the experience, age profile, and suitability, may be considered. Now, he is the youngest. So, is it that being the youngest will provide him with the criteria for being appointed? Are the others being a little older than?
Your lordships had been repeatedly putting me one question about.
Now I'm.
Yes. I only wish to assist the court with the best of my understanding. I've looked at it is not. Your lordship,
we find the voluntary retirement notification Everything.
It is in somebody else's hands.
Is that?
He is a Punjab cadre person.
No. Does it operate in there? You have seen the other files.
Yes, yes.
Does it happen like this?
No. It's just a person, a coincidence.
We don't have this.
So every time these coincidences do not really happen.
Knowledge of
Yes,
that.
yes. May I just lodge? He is a Punjab cadre person. The Punjab government is a to the extent of influencing the chief secretary of the government of Punjab to get a voluntary retirement in effect.
We are not even.
So therefore,
we are not hinting that.
That
was a tailor
but it is difficult to go into those lines.
Does it happen like this?
No,
normally?
It can always happen. Voluntary retirements, he is going to retire on 31st of December.
Attorney,
31st of December is going to anyway retire.
attorney, come to page 4
Yes.
and paragraph 3. What is your foundation for this paragraph? Page 4, paragraph 3 is the note of the Minister of Law and Justice. Paragraph 3.
Right.
What is
Okay,
the
lots of
foundation?
come back to my paragraph 6 of my note yesterday. No, please come back.
Sorry.
We say
Sorry. Your note can only a compilation of what transpires from the report.
it is the entire summing up of the convention that is being followed.
Attorney, we are
Summing up
requesting
of
you,
base.
please answer us and then we go to the note.
Please come back.
Please answer us first.
Unless you not look into that.
Attorney, we are requesting you, please answer us.
A panel is prepared.
Attorney, we are requesting you, please answer us.
I'm giving the answer.
Please, what is para 3?
Giving the
and
answer.
what is the foundation?
I'm giving the answer. In terms of the convention, retired officers, serving officers they're all prepared. Both serving and retired officers are also prepared. So the preparation is the basis of wood. Yesterday's question repeated.
Show us your note, what it says.
The note itself is self-explanatory. The other 3 officers who also been brought into the panel, they are persons who belong to the earlier batch. But by reason panel is prepared on the basis of one criteria.
We are on a different point.
Yes.
You may now justify the way the panel is there. We are not on that. He just put a question to you.
Yes.
In reference to para 3 of the note
Yes.
of the Ministry of Law and Justice,
Yes.
which we just requested. We want what is the foundation of record of the certification recorded by the ministry based on paragraph 3.
Correct. There are 2 steps here involved here. One, a panel to be prepared on the basis of the DOPT database, and who would retire at what point of time, and then what will be the tenure available to them. All on the basis of those considerations, the panel is requested. That is how it has been done.
We are requesting you. Show us
That's how it has been. No.
show us the foundation for para 3.
So you get us we would like to see, again, we're telling you this is not adversarial as you very correctly understood it. And we hope you don't take it as adversarial.
Yes.
We are trying to find out whether we should interfere, whether we should granule, because you have made a very powerful argument. We are mindful of that. That there is a system in place. And that system is worked well. There is no arbitrariness. Everything is working very well.
I would endorse that.
Exactly produces results. So it so happens that you are relying upon this ministers on the basis of the database maintained by the.
That is a database which is available on the website. Anybody can look into the database.
Okay.
Now, what happens on the basis of the database?
Just look at
A small shortlisting. For a shortlisting is something. Yes, anybody can look at the database.
Exactly.
I just said.
Find out from where is it database. What do you find out?
It's a database maintained by DOPT
Okay.
of all the civil servants.
That's right.
Yes, yes.
So how if we
A-
get the DOPT, how did the law minister, zero in on just 4 names?
A shortlisting or a zeroing in will be guided by, has been broadly guided by. So far, of course, that could be a little lapse here and there. Broadly guided by the what amount of tenure a person will have as an election commissioner, and thereafter whether he'll be a chief election commissioner. Therefore, in this case,
That's one more thing we'd like.
that's right. That's right.
You see,
That-
under the Act,
6 years.
6 years. Please read that.
Yes, yes.
It is 6 years both for the election commissioner and.
That's why yesterday note I showed your lordship.
Therefore, what
Many of them are 5 years.
That we are telling you. We understood that. Yesterday we couldn't ask you, but when we went back, we just thinking of it. 6 years is for the election commissioner. Separately, there is a term of 6 years meant for the chief election commissioner.
Yes.
If you see the act, we hope the act is very clear. Just read that. provision.
Yes,
Don't
the
mind.
chief election commissioner or an election commissioner shall hold office for a term of 6 years from the date on which he assumes his office.
Correct.
Number one. And number two, kindly turn also to.
Yes, and let's just pause for a moment. Let's
Yeah.
understand that.
Your Lordship.
We are a little slow. I mean,
I'm so sorry. I'm so sorry.
what you're trying to tell you is
Yes.
the chief election commissioner will have a separate term for 6 years. The election commissioner will have a separate term for 6 years. This is what we can understand. The meaning of that is
Yes.
both will have. Otherwise, you cannot possibly contemplate giving meaning to the proviso which says, in case an election commissioner completes 5 years before the expiry of 6 years, he will vacate office. So the term again of the chief election commissioner, if he completes
That will depend upon the.
we are saying now what happened, we understand. After
Yes.
93, when the two posts of election commissioner have been created, you have followed a pattern by which you are combining both 6 plus 6, 12, and then you are making it approximate to 6. And then you say that this is fine. It
I
may
was
not
not.
be, faithful to the interpretation which flows from very clear language used in section. Say 6 years for the election commissioner, 6 years for the chief election commissioner.
Could you Lordship just look into the dynamics of the appointment, retirement? So, is it always possible to hold that a chief election commissioner, on being appointed to have a 6-year tenure, must, before becoming an election commissioner, must still have a longer, he must enter the election commission office as an election commissioner with a fairly 6 years of tenure. Therefore, we have to go down into seniority, find out when somebody will retire, all the dynamics of flexibility. Can you therefore look into that?
That's what Sheshan complained about. That the chief election commissioner is a person to be appointed in his own right.
No, kindly say to the explanation
You
section.
have made it into a promotion post, as you correctly said
Correct.
yesterday. So what it contemplated was, you would have somebody appointed directly, because when you issue the notification,
Yes.
anybody as a chief election commissioner, his term will be 6 years. Then when you make it promotion. Even when that promotion takes place, it's an appointment. When the appointment comes, it will be for a period of 6 years from the date on.
No, therefore, how will it really work is the question I ask myself.
No,
How will it really work? Therefore, we must have somebody, an election commissioner will also have 6 years.
so it will be actually your method.
Therefore, by my reading of it, I enter the office as an election commissioner. But after I becoming a chief election commissioner, I'm sorry, Your Lordship.
What I'm suggesting.
I'm sorry.
It is not necessary. The way
Yes.
you're suggesting is that you necessarily, it's a kind of feeder category. And you have to necessarily, inevitably appoint somebody as a chief election commissioner from among the election commissioners. You have made it a kind of a feeder category. What perhaps the Constitution founding fathers contemplated was that you should have a chief election commissioner who will hold the office for a period of 6 years. Independently, not that, you make it, a promotion from, and then.
If there is a disjoint between the tenure of an election commissioner with 6 years and a chief election commissioner with another 6 years. May I just try to explain? If you read it so literally, an election commissioner will have 6 years. And then, even as a chief election commissioner, he should also have 6 years.
Absolutely.
Therefore, somebody will have a 20-year tenure in the election commission.
You're saying that somebody, on the supposition that you have to necessarily appoint the chief election commissioner by way of promotion from the post of.
But that's how the law stands today.
That's how
the law. If you want to disrupt that, then it's a different debate. Where
you say that is a law? Where is the law?
The promotion of an chief after the whole controversy in TN station, right? Thereafter, now therefore, if you have to enter into that debate, I'm only wondering: are we entering into a debate about interpretation of Rule 4, Section 4 for this purpose?
Because it stares at our faces in so many words. You say that the election commissioner will be appointed for a term of 6 years. You say separately that chief election commissioner will have a term of 6 years. What does it mean? That chief election commissioner must be somebody who is to hold ordinarily, he must be holding the office for 6 years. The proviso carves out the exception. In case he becomes 65 in the course of the term of 6 years, he will vacate office the moment he's 65. Fine. But what you are doing, you have been doing this for a long time. You are not blaming this government or that government.
No,
This is your understanding.
Yes.
That you can have a situation where you have election commissioners, make it a feeder category, make it promotion. So whether you know for sure that he's never going to have 6 years, let it be that way. Contrary to the section.
No. Perhaps not.
The
Because
last thing, and
Perhaps.
I am done.
Perhaps.
Only one last question, and we want to know, Attorney General, what we wanted to know is, we would like to see.
kindly see the dynamics of it.
Kindly enlighten us.
No, I'm trying-
Kindly enlighten
Yes.
us as to how the law minister picks up these 4 names.
Now,
What is the
there are
criteria?
3 factors. Now, anyway, somebody will retire at the age of 65 years.
Pardon?
Election commissioner, chief election commissioner, that's 65 years, right? That cap is there. So, keeping that in mind, then assuming for a minute that this practice or a convention of promoting an election commissioner, chief election commissioner is not in terms of any law, but it's just a convention or a practice, then we will have somebody who will attain the age of 65 years, but we must have necessarily have a 6-year period of the election commissioner.
That's what.
That's right. Therefore, when we
Parliament
really,
intended.
whether we can have, see, the question is not,
Parliament, that's the will of the people.
that is right, but
Yes.
then that leaves a certain amount of working of this, namely, can I have somebody with a certain amount of suitability, experience, etc., who would not hit the mark of 65 years, but still will have 6 years tenure. That choice is a choice depending upon the officers entering the civil service.
We are telling
Therefore,
you.
are we going to?
We are telling you, if you say that,
Yes,
for 40 years,
yes,
from 1950 onwards till 1989,
yes.
we were having chief election commissioners being directly appointed as chief election commissioners.
That's true. That's before the
So it is
all that.
No, we are saying that it is not as if we are saying something because we've got the weight of experience.
No,
40 years we were having chief election commissioners
are we-
being directly appointed
Are we-
from the
No,
civil
should be
service.
right.
No difficulty.
Yes.
Civil servants, because you say right from the rank of a district collector, they act as presiding officers. So there is absolutely, it is perfectly justified if you were to appoint directly. And that will be in tune with the parliamentary intention that when you appoint somebody for a term as a chief election commissioner, the term should ordinarily last for 6 years. We are only pointing out what is there empirically. What
No,
is
I
produced before this.
quite understand. But then, unless we know that the pool from which you really generate the whole system is amenable to all these questions. Therefore, a civil service, you have people entering
Have you got
a
the
particular batch, 83 batch, retiring earlier, 84 batch, retiring later, things like that. Therefore, the whole dynamics of a person's in the pool. So you look into it, and I said, who will have 6 years, who will not have 6 years, all that is taken into consideration. I hope the executive is just not. I mean, I want to clear this thing anyway. The executive, are they really playing with it because they want to play with it? I think the answer is no. I must say emphatically the answer is no.
No, whatever.
With the amount of insights I've looked into the files for the past 10, 15 years, I looked into them.
But then how did this 4 names be? How are the?
That's what I'm saying.
We are asking
The,
you, what is the
the
criteria?
persons, for instance, the previous election commissioner's appointment. Then thereafter, who are the persons in the next batch? So the batch-wise seniority people are picked up. And therefore, in order to see somebody who is a retired officer, also a convention, I told you, Lodges. Therefore,
Attorney, you are not requesting. You might be able to find out of the 4 names to give us a justification. We are not on that point.
yeah,
We are requesting you to place before us how the Ministry of Law and Justice has on their database selected by whatever the mechanism filtering down these 4 names.
there are 2
You
criteria.
may say with the names before us, and we can find out reasonable justifications both
My
sides.
earlier note which I gave yesterday, clarifying that, you'll also see how it really
Attorney,
works.
you understood what we want from you.
No, no,
You are
I'm
not answering that.
I'm only, no. I am not keeping away any.
We are requesting you.
I am not keeping
we
away.
just want our satisfaction.
I am not keeping away any answer because I have nothing to hide.
We are requesting you. We just wanted to know from you.
Yes,
Let us know.
that's what I'm trying to point out.
You want to justify after the selections?
No. I am trying to point out. Your last question is this panel, 4 persons, how do they really come? Yes, the answer is very simple. On the basis, suppose you want to have a panel of people, even retired, serving, what is their year-wise batch, what will be the age of retirement, all that comes into the reckoning of a panel of shortlisting. A shortlisting is done on that basis. If a shortlisting is done on the basis, thereafter,
Now tell us one thing. What way the aid and advice of Council of Ministers?
suppose people kindly look at this, they have belonged to the 1983 batch, 84 batch.
Where is the aid and advice of Council of Ministers gone?
Let us not get into that question today for the time being.
Why?
We are not on that question. If that question is answered, we have a larger debate again. We can open up the debate, no problem at all. We are not on that question at all. If you start doubting, I have with a great amount of reservations, if you have to start doubting every small step taken in the process of appointment of such important position, look at the implications for the integrity and the independence of the institution in outside. Now, what are we talking about?
Attorney General.
Therefore, a little dent, a small dent somewhere will make a lot of difference.
That's right. Please, Attorney General, kindly come to the, you've got a page, I think it's A8, which you have marked for.
Page number?
A8, you have put it as A8.
A8.
Yes,
That is document A8.
yes.
Yes.
We're not taking the name of the person.
Yes.
We don't want to, because that's not relevant for us. Kindly see the date of birth.
Yes.
What's the date of birth? 34/1960.
Yes.
34/1960.
Yes.
In 2022, what will be your age? 62 years.
She has retired on 30th of July 2020.
Yeah, our question is going to be something
Yeah.
different. 34/1960, she's 62 years. Even for a term of election commissioner, she could not complete a term of 6 years.
That's right.
Give an own chief election commissioner, she could never become. Now we come to A9. We are not again taking the name.
Yes.
The date of birth is 5/5/1960.
Correct.
That person is also 62 years.
Yes.
Correct? Okay, that is also same. Next
Yes.
man, 8/10. We are not taking the name. Date of birth is 28/9/1960.
Yes.
Correct? So is it the law that you will appoint only retired bureaucrats? Is it that law which you are following?
No. That's
If-
why.
if
That
it
is why.
Our
Yeah.
question is something
Yeah.
different. Our question is, you would expect that when you exercise your power, accepting all that you say, that you would act in such a way that you will also comply with the statutory intention. Which means that you are ordinarily supposed to pick up persons who would have a 6-year term, either as election commissioner or as chief election commissioner. We'll accept all what you say, but even then, the names you have picked up are such that they would not even have the ordinary term as election commissioner. Next question is the
Yes.
most important question according to us, which is this. By narrowing the scope of the panel to these 4 names, are you not shutting out those names who are sufficiently senior? Bureaucrats, we are going by your theory, the bureaucrats are the ones who are the best. So you have the 20-year rule in Pakistan for just having that as a yardstick. But we will have the same yardstick. Somebody becomes an IAS officer by the age of say 28 to 30, ordinarily. So by say, if you have the yardstick of 20 years experience, by 50, 52, 53, be fairly senior officer. Now, why do you select people? Why do you have a panel which will force you to appoint from that panel only those persons who will have, you will never have the term. We have conveyed what we are having.
No, I understand that.
If you put somebody at 62, you were to select any of these persons, then you cannot appoint them. And then you say, because this particular person who is chosen is the youngest and he's have a long term. So what happens to all those others who would have been in the same category as the person?
There is none else.
Nobody is there.
That's a problem. That's the point I want to make. Batch wise, date of birth is one thing.
Yeah.
But a person earlier in age or later in age could have entered service at a different point of time. Therefore, the year, the batch wise cadre, all that is taken into consideration. So if somebody belongs to 83 batch, 84 batch, 85 batch, therefore you go with batch wise.
That's right.
Somebody could have been senior in a later age. So all those dynamics comes in. Therefore, how do I draw a line between the pool of officers who should be picked up?
So
How do I really draw?
So the point is that you have to also violate the law. If your theory is accepted, that you are hell bent on saying that nobody will ever have a term of 6 years as election commissioner or as chief.
No, I don't think that intention could be imputed. I don't think, with great amount of respect.
You know,
With a great amount of respect.
What you're saying, and you know that. Still waiting to see. You're saying that the council of Balbir Singh was saying that if you put in place this, not that this is just we are all considering various possibilities.
Yes.
You never get the impression that
Yes.
made up our mind in any manner. When we ask questions, it should not give the
No. Certainly, I'm bound to answer all your
impression. Nobody.
It
It's just a debate that we should be having.
It's a debate which I think all of us must play a due role. And I certainly understand what my role is.
We are clearing the air that there should not be no impression in anybody's mind that we are against you or their favor or anything of the kind.
Certainly not. I will never get that impression.
So what we wanted to know was Balbir Singh was heard arguing that if the suggestion of the petitioners is accepted, you will have what's called a pure recommendatory body in the form of this collegium of the Prime Minister, the leader of the opposition, and the Chief Justice. Now we have the cabinet system, Article 73, 74, 77, rules of business. Therefore, once the collegium recommends, will it not get stuck in the proceedings of the Council of Ministers? Because it has to pass through the Council of Ministers' recommendation. Now there, we want to just clarify, because it was pointed out last time, that under the rules of business, you have framed actually the matter relating to appointment of the Chief Election Commissioner, the Election Commissioner, we only go to the Prime Minister under the rules of business. We want just confirmation about that. That's a procedure.
That's a procedure.
He doesn't have to go to the cabinet. We wanted to know that.
That's a procedure.
No, Balbir was saying it has to go to the
No.
cabinet.
He was. Because there are other appointments, the ACC appointment.
That's right.
ACC appointment go through a cabinet secretariat.
So
but the level of responsibility and accountability, there can't be a difference.
Absolutely.
And then there are different categories of
So now let
appointments.
him continue.
That's right. One last clarification. I want to lost attention to section 6 of the Act.
Sorry?
Because there is a question about voluntary retirement and all that. I told you a lot. The central government or the Prime Minister's office has nothing to do with somebody relieving somebody from his cadre. We have nothing to do with that.
Incorporated the details, and in third tab, information sought for is reflected.
Okay. You get that one? Can you take the notes? Whatever is there.
Print out.
Take your losses, just
Brother. What are you saying? Attorney General,
Your Lordship.
you said that there are no other officers who are, are not going to retire and things like that. We'll just give you from Punjab itself. They're just taking a name. Or we'll not take the name, but we'll give the date of birth. The date of birth is shown as 1/9/10/1973. She's a level 17 of in the pay matrix, same as the other officer. She's a chief special. We'll take only the name. Special Chief Secretary to government. We are not going to name the department. She is 1963 born. So your age there, that there are, you want to see this? We just.
So I know
That 88 batch officer. Now, this gentleman is an 85 batch officer. If you go state-wise to the other states, you'll find there are 85 batch officers who have born after December 62.
Yes.
The first man in Tamil Nadu, for example, the first person in Maharashtra, for example, the first person in Madhya Pradesh, but they're not.
No,
We are not,
Yes,
so sorry.
we are not examining the issue as to who is it.
correct.
We are on the procedure.
Exactly.
So therefore, my elected logic is have a panel of 100 names, right? Pick up among them. Even then somebody will say, please don't get
We are
it.
not saying that.
What-
We're misunderstanding or deliberately not trying to understand what we're saying.
What we are saying here.
Yes.
We checked it.
Yes.
We thought that, nobody, you said there is nobody, who is.
No. The question is, if you have to have an unwieldy pool, right? Then the question of first selection, second screening, third screening, how do we really go into the screening process? So every time somebody is screened out, my elections will come and say, look at what have you done? Are you therefore getting into a question?
What is the criteria which a law minister employed?
For
We'd
if-
like to know,
if
will
you
you
hit
pick
the-
up 4 names.
Then it should be 4 instead of 4, 8, 10, 12, 20.
8, 10.
No, I'm
Let
a
us hope
little.
we are not
Yes.
sort of
I'm so sorry.
trivializing our
And so-
worry. Our worry is basically purely, legal. What you're saying is when an executive body is acting,
Yes.
power, constitution, or it's an executive power act. Basically, it's a power which is being given to a point, finally, under the constitutional provision. So you have the Wednesbury principle, but we are not doing that judicial review as such, but we are on the whether we need to step in. Very, very important mistake, as you said, we said with a lot of difficulty. So we were a little mystified. How would you pick up from a database, which you say there is, of officers, only, and we pointed out 3 out of them could not possibly, fulfill the requirement at all. There are others, it is pointed out. And it's from the list which you asked us to see, we found there are others.
Let me.
So then how do you answer that?
No, those persons who would not. No, look. We try to explain.
You want to say something? Sorry.
Okay, I want you lot to look at also section 6. Before I come to section 6 of the Act. Now, batch is one important criteria.
Pardon?
The batch to which a person belongs is one criteria. 83 batch, 84 batch, 86 batch. That batch is the criteria. The date of birth will be a criteria only for to find out whether somebody would have a reasonable tenure before entering 65 years. The third is among batch seniority. So would be senior among them. So these are 3 or 4 factors which come in. Now, therefore, I ask myself a question. Having regard to the practice which has prevailed over a period of time, it is comfortable. If it's comfortable for a zone of consideration with small number of people and who are found to be otherwise, and after all, the government knows, depending upon the service profile of a person. Now, to go beyond the service profile and to now say you are having a very short panel, and the short panel has been decidedly designed to pick up somebody who will fill up your bill.
Yes.
To reach that conclusion, I think would be very, very difficult. The court will now put itself into the decision-making body or a thought of a person who is otherwise held to be accountable for the very important decision somebody is making.
We only ask you one question.
Your Lordship.
We'll give as the last chance, we'll ask, I'll
Yes.
stop asking. Was there any criteria for the law minister to pick out these 4 names?
That's
Just
what I'm
tell us
trying
one
to explain.
criteria.
That's what I'm trying to explain, Your Lordship.
One criteria.
You see, initially it is a question of batches. the batch is coming. So among the batch people, will somebody have a longer tenure? That's another consideration. If that consideration is wrong, then I think no other consideration can help us. It is therefore a question of who will fill up as nearly as possible the requirements of the law.
So you went by batch.
Yes, batch is taken into consideration.
What batch? means?
Kindly turn to the same page.
84 batch you are saying.
Kindly turn to page 4.
So therefore you are saying that only persons who are on the verge of retirement should be appointed.
Yes, yes, that's what I'm trying to point
No,
out.
ultimately you are saying that we have to put.
Batch is one criteria. Among batches, who is senior? Among them, who is probably other profile and suitability? Therefore, 1, 2, 3, 4, 5. So these criteria, then somebody will score out 1, somebody may score out 2.
So
then how do we have a selection process?
What you're saying is therefore that persons who are on the verge of retirement
Yes.
who will definitely not get the term of 6 years either as an election commissioner or as a chief
Correct.
election commissioner are carefully picked and chosen.
No, therefore that's why I'm saying for in a
Is there a
given
Is there a rational criterion?
in a given situation,
You're
you may have,
violating the law. You're violating Section 6. We are telling you openly.
no, your lordships are right.
They are
Therefore,
expected to get 6 years.
no, but I only want to ask this question: how do we really come and honor this 6 years criteria? I said either a chief election commissioner will not be any longer promoted from election commissioner. We must do away with that convention or a practice. Then what happens? Somebody comes to an election commissioner, he will have 6 years tenure, walk out of the election commission after 6 years of tenure. Then we have to find out a chief election commissioner who will be appointed chief election commissioner. Therefore, we get into an imbroglio prior to TN session case. Why do we get into an
Mr.
imbroglio?
Attorney,
Yes.
we are completely with you. Whatever the mechanism it is available at your command, you adopted it. Nothing
Yeah.
wrong in it.
Yeah.
We are not supposed to question, and we are not questioning. And worry, anxiety is only one, which is not this. What is mode you adopted? If you see 85 batch or 83 batch, whatever the batch is, and you go to the database, you will find the age factor, the batch factor, the profile factor of the persons of a particular batch. You will find large number of officers. Our worry is not this to whom you select. It's your choice. It's completely within your domain. You have to do it.
Yes.
Completely. We are not on the question. If 85 batch or 83 batch is the denominator for the purpose of filtering the candidates for making a final call, fairly good.
Right.
But you said we want to keep in mind the tenure of the person to complete 6 years nearby, looking to the age factor and
Yes.
his entry level to election commission.
Yes.
Because according to you, election commission, and that very person later on appointed to chief election. Very good.
Gotcha, sir.
You want a person must have experience of election commission
Right.
before he is given a charge
Right.
of the post to help other affairs. Nothing wrong.
Right.
Absolutely. We don't have anything to say. But if you are selecting a person of 85 batch
Yeah.
with an age factor of 62, 61, 63, whatever it is, your choice. But you will find if you go to the database, because you are downloaded from database, and this is a filter from database. If you go to the database, you will find the combination of date of birth, the combination of
Sure.
the batch,
Batch, seniority.
may be almost similar. And you will find, suppose, 20 people
Yeah, lordship.
of the age factor and the batch factor from various state cadres.
Right.
Okay. Our request, what we are following to you,
Your lordship, please.
we are on a different point. We want to know from you what is the mechanism which the Department of Law and Justice adopted to filter down and select 185 batch officer of this age. This is our question to you. I think we made ourselves clear to you. If you have 20 officers,
Yeah.
25 officers of 85 batch with almost the same age factor available on the database, so you can select. Absolutely, it's your domain. But we just want to know from you what is the mechanism you adopted to filter down and select one officer of this age factor with this batch as the only officer under the
Very well.
filtering guide.
There's only two ways of looking to it. The one way is, I want somebody, therefore I'm picking him up. Regardless, ignoring all other factors.
We don't say
Ignoring all other factors, I want somebody, I'm picking him up. That's one way. Then the other way is, no, I have a certain comfort zone in not getting into an unwieldy panel. Then I may have to find out how to weigh the relative profile, suitability, experience of a large number of people. How do I really weigh them? It's a very difficult weighing experience. So the larger the field, then of
If
course
you have to
the
do it,
large.
if you have to do it on one day,
Yeah,
you have to do it on one day, on
Yeah.
1811.
yeah.
Everything is done.
No, these are all factors which
No,
in a given.
the files.
No. I only want to.
One day,
I only yes.
1811.
Can I just have 2 more minutes?
Sorry?
Can I have a kindly turn to section 6 of the Act.
Certainly.
91
I
Act.
just want to point out that there are some disquieting features which I thought we present to them. And I want to dispel all that impression. And I thought there's nothing confidential about this document. We have shared it with them.
I've been very fair.
That's the best way of instilling. That's the best way of instilling and enhancing the quality of debate in the court and to ensure that the independence is also ensured in that. And therefore, that's
Section 9.
section 6,
That's in the body
page
one.
153 of the compilation,
Volume 1.
volume 1.
151, page 151.
Before I read that section, so any person, this gentleman is otherwise superannuating on 31st of December. And regardless of the age of superannuation, if the government finds among other persons the profile, I think you would better serve and you can pick him up. So the government picks him up. So the question whether he will retire or not may not weigh with the government. And if, for the purpose of comfort and convenience, that I'm going to retire anyway in 31st of December, let me seek voluntary retirement. He seeks voluntary retirement from a cadre on which central government has no control whatsoever. And they respond to the voluntary retirement request and is given voluntary retirement. That will not make a difference whatsoever for the government to take into account whether his profile is important, not a voluntary retirement question.
That's correct.
So kindly turn to section 6. A person who immediately before the date of assuming office as the chief election commissioner or an election commissioner was in service of government, he shall be deemed to have retired from service on the date on which he enters upon office as a chief election commissioner or an election commissioner.
That's for the purpose of pension.
That is true. That is true. Therefore,
what is the question? We are not concerned with the
no,
question of pension.
because that small grey area where it says, oh, he's taken voluntary retirement only for the purpose of a nudging from somebody, get him voluntary retirement, now make him election. All that is
Just read the most crucial provision.
yeah.
When you're talking about this act is framed in accordance with 324(5).
Yes.
Conditions of service.
Election.
Election.
Right.
The term of an election commissioner will certainly form part of the terms and conditions contemplated. So in that term is very important. And you say the chief election commissioner or an election commissioner shall hold office for a term of 6 years from the date on which he assumes his office. Then you have this proviso which you incorporated in 93. After 91 Act came, you made it in 93 by an ordinance in
That's
80,
right,
and
that's
that came in by an act. So do we have a situation where the proviso will actually overwhelm the main provision every time? The proviso becomes the rule. See, when you're interpreting this as, you have to understand what Parliament
That the tail will not wag.
So we get here a situation where the rule says he shall have, it is not may something like that, he shall have, it's imperative. Both as election commissioner and as chief election commissioner, because the separate appointment orders will be there. When even if you promote somebody, you can produce that, we have any doubt.
Certainly, it's well received. I'm not sure.
So he will have term of 6 years. Everybody knows that he will never have it.
No, this question certainly come into our mind. We had discussions where the only possible answer is yes, it happens like that, but there is no design. There is no design.
It does not happen like that.
No.
What you're saying?
No, it's very difficult unless I have a 40, 50 years of profiles and show how it has happened, why it has not happened, how the choice has been made.
Need not
That
have-
exercise,
the
maybe.
point is, Attorney
Yeah.
General, what really binds us, guides us is the will of the people speaking through Parliament, the law. The law is a clear guidance. The law says, shall have 6 years, shall have 6 years. So ordinarily, your effort should be to see that law is actually observed, not in its breach, but in observance.
I can't be in disagreement with it. I'm not even saying
That's
anything.
all we are saying.
All that I'm trying to say is having looked
Now
into,
the time is up, and let us go.
having looked into that. Therefore, this disquiet that's being taught, I say yes, in my understanding, very humble understanding, the way the system is working, how the convention is working, and how there is nothing in which, I don't think there is a possibility. If the court were to go to the extent of saying there is always a quid pro quo in the appointment, I think that court is not.
We are not.
That's right.
Absolutely not.
Correct.
We don't know from where you gather it. We never thought it. And we never think it. Sorry. We are only on the question of the procedure. Absolutely. Don't take this impression.
We are also not saying it.
Yes.
No, but what's the suggestion?
No.
You're saying there's a process which is
We are
flawed.
not.
The process
We are
which
not
is
on
flawed.
at all.
Yes,
Sorry, we are not on this issue.
yes.
Absolutely not.
You see, yesterday we requested for the file. Today you have produced it. So to that extent, we say good thing has been done. All right. Now you are trying to justify on the query of the court that the law minister
Yeah.
has shortlisted 4 persons, 4
Yeah.
names from a large database. We try to understand what is the basis for shortlisting these 4 persons. We are still struggling with the logic and the reason, right? Talk about age, you are giving 65 years. But perhaps there will be many more officers who fit in the profile that you are trying to suggest in court was the basis for the law ministry's shortlisting these 4 names out of the data of maybe 100 people, that age category. Now, age category is relevant because you have a particular tenure, you have a particular age related to the office, 65 years. So it's relevant. You may be right in saying that the age is the criteria on the basis of which we have shortlisted these 4. But if we find, and of course, we have also said that we are not testing the appointment of this particular person. We are basically in this process.
I quite see that. It's very
Testing
important.
the process.
I-
Testing the process.
Correct.
So what is the process through which you make the appointment of
Yes,
election commission?
yes.
If we are testing the process, and if you say that age is a factor, and it's a factor, it's a relevant factor, but if we find that besides these 4, there are 40 others who also fit into the same age factor,
Correct.
then why 4? Why not the other 36? This is the question that we are
Certainly,
trying to
it's a
pose.
this is a well important question.
And one thing, we have talked about the silence of the constitution, just to lighten the mood a bit, just to lighten the mood of the bit.
Your Lordship, please.
You have given 8 points in your note. Attorney General's note contains 8 points.
Yes, yes.
If
It is
there
silent
was,
about something else.
yeah, the 9th note is missing, and that could have been the Attorney General saying that election process is all about numbers, and the man who has got a gold medal in mathematics, we have shortlisted him. That note is missing.
I didn't want to put myself in the place of those who have taken the decisions. Hey, just one small concluding. This question will certainly keep coming. Why 4? Why not 5? Why not 10? Therefore, any number of persons who will be placed on the equal footing on an outsider's point of view. When I say outsider, from an external agency. The internal agency now knows how wide we can have a selection band. How wide it can be. The more it's wider, I repeat, as narrow or wide, the question of discretion will always be questioned. Will always be questioned. Every third seniority of appointment matter, from the highest to the lowest level, including judges' appointment, before this court.
That's why we thought that why the rules have so far not been framed when the legislature and the constitution.
That's an important question.
If the rules would have been there, The mechanism
Even
process
then-
would have been
even-
very filtered.
Even then, your lordship knows, after rules have been framed, don't we have seniority disputes in the country for the past 50 years?
That's a different thing. You're right.
Seniority, even
So you want to
seniority
say
in the
that why should
context
we-
of high court employees.
You want to say that why should we have a rule that
No,
disputes
no,
will
I'm not
remain
saying
there?
that. I'm not saying that.
Avoid all rules and go ahead.
Seniority in the context
Ultimately,
of,
this court will take a call and decide.
no, please don't misunderstand me like that. I'm not saying that.
Rules are framed. We know it. Every time this court is intervening and the seniority rules are always breached. But still,
Let us look at, that's why yesterday I think I'm taking the lordship's time because it's a very important sharing of thoughts and ideas, and it's going to certainly enhance the quality of decision-making process. I'm very clear about that. But the certain institutions and certain processes probably are best left to certain informality, and when that informality brings about a confidence, then there is no difficulty at all. But whenever on a given occasion, that informality breaches that confidence level, the court will always look into that. But for that purpose, in a given case, a certain doubt has arisen in the mind of the court, then will the court go to the extent saying, I think we will have to now look at the informality. We don't know whether we can trust it, and therefore we'll try to tighten it up.
All right. Thank you.
So that would be a little closer to keeping that, play in the joint. But after all, we're not looking at appointments at a very ordinary level, at a level where other considerations may or may not come. But on one last thing. This, you Lordship put me a question, it happened in May. What happened in May? Many things are, this very highly confidential thing. Informally decisions take place. When do we do it? How do you do it? Therefore, nothing is kept on black and white. It's not like an ordinary note sheet in any
if
circumstance.
the vacancy was available to you on 15th of May, then what was that emergency
Let me
came across
Let me
that
tell you, Lord.
one
Very-
fine
very-
morning you have rolled out the whole system?
Nothing to hide.
Yes.
There is nothing to hide at all. Nothing to hide at all. Even before on taking certain things on my shoulders, I must tell you, Lordship, what happened.
Okay.
Because these things come before the court.
Thank you.
Even before,
Let us get
I'm
on.
sorry.
Let us get on now.
Yes.
Let them come.
Even before the matter was heard,
Sorry. Yes.
then I was asked whether any impediment in going about the appointment. Was there any problem? Then I thought about the matter. I didn't find there is any injunction or a stay or something like that. There is no reservation on that. And precisely they quoted that there is no reservation going about the appointment. That is how it went ahead. So it took probably about a week's time after I gave my consultation, and then you started moving it. So therefore, the speed part of it was also after my consultation with.
That's all. We are done.
Therefore, I don't think your lordship will see any rat in that. It's very important that certain things take place at a very highly consultative, confidential level, and things are and advice and.
Thank you. Thank you.
That's how.
Thank you.
And I thought, keeping in mind the independence of the office of the Attorney General, the advice that I give must also carry weight and confidence, and then it should not lead to any what I call even remotely a remote link or use for anything out of the blue. That's all I want to say.
Thank you.
On a matter of fact, my lord, there are 160 officers from the 1985 batch, IAS officers from the 1985 batch. And also on a matter of fact, some of those from the same batch are younger who would have a longer tenure. This gentleman will have a tenure of 5 years. The others would have a tenure of 5.5 or so years, etc. From that batch. Secondly, out of those other 3 people that they have shortlisted, there would be many, many more who are not only senior but younger to them. They have given.
Go through that.
Yes.
You'll be going through all these.
Yes. They have given this chart
Yes.
of the election. Mr. Balbir Singh gave this chart of the election commissioners and their tenure. And if your lordship just sees this chart,
Original file, give it back. You don't need it. Let's just see. Copy which you have given.
so he gave your lordship's chart, which was typed by Mr. Balbir Singh, giving some more information.
That's part of your original file, I think. We are giving it back. You've given us a copy, anyway. We are giving back the original.
Your lordship, please.
You don't need to. You've given us the old copies, I think.
Yes.
Because yesterday when your lordship asked me this question.
1 minute. Eh?
Yes, yes. pointing out a lot of facts.
Yes.
This chart which was given of the election commissioners who have been appointed
Yeah.
in the last many years shows that from Mr. Let's take from this chart which Mr.
That's right.
From 9 to 15, all of them have had tenures of between 2 to 4 years. So this logic which is now being given clearly was not applied earlier. Today we are being told that no, he was selected because he would have a long tenure of over 5 years. But certainly many of the people who were appointed earlier had tenures of less than 3 years. Now, I filed this IA.
Mr. Bhushan, let him complete.
Yes, just one fact. This IA was filed for interim relief in May 2021.
That's why we are aware of that. We are
And
conscious of that.
yes,
We're conscious of
it
that.
was
We
mentioned
don't-
in my arguments on the
All right.
17th.
Let him conclude.
Yes.
Otherwise, it will not be good. Yeah, 10 minutes is what we had promised you from what 20 minutes you wanted, but we'll give you time.
1.5 hours, I've
We
been.
have already spent, but
I'll take a little more than 10 minutes.
Yes.
There is something to be said.
Yeah.
Apropos what has just happened. I'm
Okay,
grateful.
just, Gopal, if you can
Yes.
just concentrate on that vacuum.
I'm concentrating on that. I've got something more in addition. It's helpful when we are on our legs at 4 o'clock. It gives us time to rush away and do some additional homework. I'm grateful that we have this Arun Goel appointment file before your lordship, because until now it was a vacuum for us, because we had absolutely no clue what is the procedure, how they shortlist, what they do. What we had transparently available, and which I addressed in the opening arguments, I showed your lordships the rules of business. Their rules of business says Prime Minister and President. Now we know that there is a convention of Law Minister also. Why Law Minister for the Election Commission? I don't know. I don't know whether he has, as against say, any other minister, whether he is better positioned. But that's a choice they make. I have no issue. But I'm saying,
Historically, what we know is a law minister has been
perhaps,
initiating the process.
perhaps. I will be saying perhaps many times, because we don't know. It's not written. Even now, several questions have been put by this bench to the learned Attorney General, and there's been no answer about, is it written? Is it there transparently for us to see? Is there a rule? Is there a law? The answer consistently to every one of these questions is a big, fat, resounding no. It's only convention, some ad hoc practice. The second thing that we know, and I'm grateful for the question that fell about how the proviso is serviced over Section 4. The 1991 Act gives a tenure of 6 years. That tenure is provided by Section 4. Till today, they have never, not once, had anybody with 6 years. Not once. Not for Chief Election Commissioner, not for Election Commissioner. Third point, and this is important. In service jurisprudence, we understand cadres. We understand promotional avenues. Here is the other gaping, yawning silence. Election Commission has now become a cadre. There's a promotional avenue between the Election Commissioner and the Chief Election Commissioner. This is strange to me, because the law tells me that the Chief Election Commissioner has a fixed tenure of 6 years. The law tells me that his two companions have fixed tenures of 6 years. The law in the proviso says, by chance, per chance, you happen to be, say, 60 years, 59 years and a few months. Then, when you hit 65, exit. Apparently, they've completely lost sight of the main provision. They've gone only by the proviso. So, and I will show, there's a chart which I've annexed also, which shows at what stage they appoint them as Chief Election Commissioner. Parliament has told the executive, you must ensure they have 6 years. Why? Why 6 years? The reason is, just like it is with tenures of judges and everything else, that there is security of tenure. Security of tenure is independent for independence. You put a man in for 6 months, for 8 months, for 10 months, so that there's a leash. This is not an argument saying malafides. We are not saying malafides. We are saying forget what your intentions are. They might be the noblest. It doesn't seem to us that this institution can be strong and can be independent if there is a perception of a leash that is being controlled, giving you small tenures, allowing something which Parliament did not allow. Parliament insisted 6-year tenures. Not once have you serviced there. And how do you tell a election commissioner who under the law is told that he has 6 years? How do you curtail it? I ask myself this. It's a tenure which according to them constitution has deferred, Parliament has made a law. It says 6 years. That election commissioner has to get 6 years. You can't tell him after 2.5, we're making you chief election commissioner. You can't. There's no question of curtailing that tenure.
Yeah, put it to him.
Yes. So for me, I just wanted to once again explain what our position is. Unequivocally, because lots of arguments have come from the other side on things which we are not saying. We're not arguing Malafides. We are not saying that the only competent people are people outside of the executive. We're not saying that. What are we saying? We're saying two things which are the essence of this constitution. One, independence of the election commission. And I'm inviting your lordships to use that phrase in this judgment when it comes, that the independence of the election commission, whichever way you lordships hold finally, it's important because we are not finding it in this context in any judgments of the court. Dhanova and Session in a different context. But in the larger context of how your lordships came up with the independence of the judiciary, it was there in the directive principle. This is Bose mentioned, yes.
What do
But-
you mean by independence?
Independence of the election commission means this, that the chief election commissioner and the election commissioners must be first appointed through a very visible and clear process which has no single dollop of arbitrariness in it. It cannot have.
How do you do that?
By following time-tested methods which your lordships have laid down for many, many institutions. And I'll tell your lordships, if there is one institution where your lordships have had to fill the gap, we have an entire swath of 17 judgments where your lordships have had to fill the gap, it's been the election commission. Not once, 17 times. Because something is not filled up, there is a gap here, we'll say lay down guidelines. Try and follow these procedures. There's something here, fill that up. You have done this. And you've always had to do it mainly with the election commission. Why would you? Your lordship could accept the Attorney General's argument saying, please, hands off, don't touch it. You've touched. You've gone much further than touching. You've actually framed and laid it down. When a law was made which was contrary to your lordship's guidelines, just accepting half of it, you've struck down that law. So you've done this repeatedly with the election commission particularly.
Mr. Shankar Naik,
Yes.
just one thing.
Yes, ma'am.
You've talked about the proviso overriding the
Yes.
main provision.
Yes.
Now, the proviso, I find it came later.
Yes.
93.
Inserted
93.
later.
93.
Now, is there any justification or any explanation why it was inserted, making it 65 years? And also, you are talking about the short tenure argument, keeping them on leash.
Yes.
Now, does it mean that suppose if you have a 6-year fixed tenure provided by the main provision, section 4,
Yes.
then even if you cross 65,
Yeah.
you should be continuing beyond to complete your tenure? Are you trying to
No.
make an argument of
No,
that?
I'm not saying that. The law prohibits me from making that argument unless I challenge the law. I'm not challenging the law. I'm saying when you're doing your empaneling, your encadering, etc.,
At the stage
Your-
of shortlisting, you must
correct.
keep that into account.
Your pool, because just now, I mean, apropos what fell, we went to the same website, which has the entire civil list. It's an ebook, but it's cadre-wise, so it's a little painful rather than batch-wise. So we had to go state by state. When we were looking at the state, we saw many, many people who are secretaries, resident commissioners, very senior positions throughout, who are 86 batch, 87 batch, 88. You can go down to 90. I think this obsession with having people who are so much older, I ask myself that. I mean, you can't have an election commissioner who's 50 years old. Is there some magic line that you have to be?
I can only say that argument coming from Mr. Gopal on the age factor is very appealing.
My hair will speak otherwise. So I'm just saying that definitely should be a conscious necessity that when you start with whatever empaneling process, shortlisting process, look at people who are in their 40s, look at people who are in their early 50s. You hit 60 and then suddenly you start empaneling.
Should we, as judges, determine that?
Not determined.
We are voting people to
No, absolutely. So I'm not saying
Parliament and Assembly for deciding these things.
which has been decided. Which has been decided. I'm grateful for that. Which has been decided. And in section 4, Parliament has applied it. Old, wizened, grey hairs have applied their minds to this and said, of course, now not that old, many of the parliament are very, very young. They've applied their minds to this and said, look, we need to give them 6 years. If Parliament tells you to give 6 years, your empanelment process must start with people who have 6 years to give. It can't start with people who have 5 years to give and say, among those who have 5 years to give, this one man is the youngest. After shortlisting 4. You're also absolutely right. They chose.
Already like that. We have already
Yes,
flagged.
I won't belabor that. I won't belabor that. Now, what I will belabor, if your lordship don't mind, and this is directly linked to that vacuum question and to my Lord Justice Rastogi's question to me when your lordship rose yesterday, which is that if that subject to law phrase were not there, would our argument still stand? And I said, yes, it would. And the reason it would is because of this principle of the independence of the Election Commission. It's not a principle that hangs by a thread somewhere. It's very much rooted in the provisions of the Constitution and even further down in that basic feature that is democracy. Your lordships have a passage in that Gujarat special reference which perfectly captures it. The idea is that if you accept, and I think we all accept, that democracy is a foundation on which this nation has been built, and if it's built on that, and we are not, as I heard the Attorney General yesterday, and they of course say that, we are a very young republic. We're not a young republic. We're the 7th oldest republic in the world with a democracy. 7th oldest. That's not very young. 72 years. I don't think we can still keep calling ourselves young beyond a point. 72 years means opportunities have been given to several generations to sort out what the mistakes and problems are, to fill up vacuums if there are vacuums. 30 years were given to them to fill up the vacuum. PNs were sent to them from the Election Commission, from many other commissions. They've chosen not to. Now, if the independence of the Election Commission is crucial to that value that we hold dear, that of democracy, and the functioning of the Election Commission must then be ironclad to ensure not that there is a wrongdoing, but even a perception shouldn't arise. Much like we say of the judiciary. The independence of the judiciary doesn't mean, as was argued yesterday, that we had judges who were questionable before the collegium system came in. Not at all. We had exemplary judges then, we had exemplary judges after that as well. But the question is, the system should be seen to be reasonably independent. And this is not for the executive or for any one body, it's for the people of this country. We are arguing on behalf of the people of this country, on the citizen. Now, on vacuum, there is a note I prepared, and I want your lordships just to see that. Give 5 copies. How specifically with reference to the judiciary. I'm now drawing this parallel, and your lordship will keep this parallel in mind. Independence of the judiciary, your lordship found vacuums, you filled it up. I'm saying independence of, I'm saying independence of the Election Commission. If your lordships find a vacuum, I'll make it good. Please fill it up. Give me one copy. I don't know. I've just taken the extracts. Your lordship familiar with the fact of these 4 cases.
When it comes to judges' appointment,
Yes.
did it turn on a principle of interpretation? Whether you were consultation made it concurrence.
Correct. But
that was
Two
whether we went far is again
to interpret.
rather than
Yeah, of course. And your lordships, all I can say is, did your lordships revisit that once, twice, thrice? Your lordships revisited that position. I would, since we had gone into facts, we got into trigger points, let me respond to that directly. In 1980, some of the top lawyers in this country filed petitions before this court. Mr. S.P. Gupta filed, Mr. Iqbal Chagla filed, all part of that same batch. This was a trigger point, if at all could have been argued, saying that after Indira Gandhi brought in the emergency and the Jabalpur bench buckled, ADM Jabalpur bench buckled, that would have been the trigger point for creating a collegium, creating independence. But did the SP Gupta bench do that? They didn't. So this requirement of a trigger point, I don't think is absolutely necessary.
So, no,
It can only add to it.
Veeraswamy is, I think, you're referring
Yes.
to that underlying portion.
Yes, I'm showing your lordships these judgments to show where legislative vacuums existed.
we just make that note.
Yes,
a note.
I'll just read these. I've just taken these extracts. I don't want to trouble your lordship with the books. In Veeraswamy, on whether Supreme Court and High Court judges can be prosecuted under the Prevention of Corruption Act, I'll read this para. But counsel for the appellant has reservations. He maintained that it would be for the state to come forward with a separate enactment for the judges consistent with the constitutional provisions for safeguarding the independence of the judiciary and not for this court to improve upon the defective law. In our opinion, there is no need for a separate legislation for the judges. The act is not basically defective in its application to judiciary. All that is required is to lay down certain guidelines lest the act may be misused. So they're not waiting for trigger points. They're saying lest it be misused.
Yes.
All that is required is to lay down certain guidelines lest the act may be misused. This court, being the ultimate guardian of rights of people and independence of the judiciary, will not deny itself the opportunity to lay down such guidelines. We must never forget that this court is not a court of limited jurisdiction of only dispute settling. Almost from the beginning, this court has been a lawmaker, albeit in Holmes's expression, interstitial lawmaker. Indeed, the court's role today is much more. It is expanding beyond dispute settling and interstitial lawmaking. It is a problem solver in the nebulous areas. In this case, we consider it no mere opportunity. It is a duty. It is our responsibility and duty to apply the existing law in a form more conducive to the independence of the judiciary. Vineet Narayan, I haven't set up the guidelines, your lordship knows what the system is. Vineet Narayan, just this paragraph again. As pointed out at Vishaka, it is the duty of the executive to fill the vacuum by executive orders because its field is coterminous with that of the legislature. And where there is inaction even by the executive, as your lordship has seen, inaction in this case, for whatever reason, the judiciary must step in exercise of its constitutional obligations under the aforesaid provisions to provide a solution till such time as the legislature acts to perform its role by enacting proper legislation to cover the field. Delhi Judicial Service Officers
Yes,
Association,
yes.
where Article 142 was interpreted.
Well, we have seen it. We have seen
I
it.
will add a little bit of intonation when I read it out, so permit me. The facts of the instant case demonstrate that a presiding officer of a court may be arrested and humiliated on flimsy and manufactured charges which could affect the administration of justice. In order to avoid any such situation in future, we consider it necessary to lay down guidelines which should be followed in the case of arrest and detention of a judicial officer. Such situation in future. So, no trigger point may come. No person, whatever his rank or designation may be, is above law and he must face the penal consequences of infraction of criminal law. A magistrate, judge, or any other judicial officer is liable to criminal prosecution for an offence like any other citizen. But in view of the paramount necessity of preserving the independence of judiciary and at the same time ensuring that infractions of law are properly investigated, we think that the following guidelines should be issued. Common cause and diagram I'll treat as read. Now, the tests, therefore, are not just limited to the question of there being a trigger. Did something suddenly happen? Something suddenly didn't happen with reference to how the independence of the judiciary was asserted in a series of no trigger points. In the first two cases, it was only on interpretation of the question of concurrence, and the second was with reference to Chief Justice being expanded to mean a collegium of 3 than a collegium of 5. No trigger points. The trigger point may have been the constitutional amendment which was directly challenged, but otherwise no trigger point. The second aspect is, of the 12 categories of unelected constitutional authorities, I'm saying unelected specifically because these are all appointed or this other process, it is only the Election Commission and the National Commission for Scheduled Castes, only these two, where no qualifications have been laid down either in the Constitution or in the law. No eligibility provisions have been laid down. No question regarding this, particularly in the Election Commission situation, if there's promotion, etc. As of right, there is nothing laid down regarding that. The criteria for creating panels, none of this, there's silence on all of this. Pages 1 to 3 of that spiral bound has the entire chart with the columns showing that. Now, maybe the National Commission for Scheduled Castes also there's a vacuum that needs to be filled up. But the only question is the pressing need and the consequence of not filling it up, filling the vacuum. Here you have a very serious consequence of such a vacuum continuing. and if anything, this file has shown your lordship, is that there are many questions. I don't think any of us can deny that there are many questions about a decision being taken on one day. And we must ask ourselves, we're always presuming that all these authorities are functioning perfectly in accordance with norms, proper norms of governance. What is the material before them? In one single day, you empanel, you pass on names, biodata. If they have one question or query, they want to find out a little more about somebody, nothing happens. It all gets done in one day. We find lots of dissatisfaction with 23 bills being passed in one day by Parliament. Now we find the executive doing something similar on a single day. We expect for something like the election commissioner of this country that there will be a little bit of deliberation. I don't think that's too much to ask. I don't think any person representing the executive can possibly tell your lordship, no, we want to do it in one day. Impossible. In my view, as far as the constitution is concerned, deference, deliberation, deep thought, questioning. Maybe you want to meet those people, you want to find out what their thoughts are. All that is necessary for any constitutional position. I'm not only talking about this, I'm saying any constitutional position. There is deliberation, there are interviews, there are many rounds of things. What is this one day business? Have we descended to such chaos that we will appoint somebody as high as the election commissioner in one day? Now, the one vacuum I've mentioned in comparison to the other constitutional authority. Second, I mentioned yesterday, so I'm not going into it again, about how those.
Pardon?
Yes. Yes. My apologies.
Yes, so that, you know.
Yes. No, absolutely. Yes.
So you have made your point there, so that, you know, we understood.
Yes.
Can we close it?
Well, I have some more. I mean, I've spent a considerable time creating this compilation.
You wanted 20 minutes, we have given you.
Just give me 5-6 minutes. I mean,
5 minutes.
These are new facts.
Okay,
You give me 5-6 minutes. I'll finish by 12:30. Your lordship will give me till 12:30. I'll wrap it up. But I didn't anticipate that the Attorney General will take this much time today also. So just, your lordship may give me a little bit of time on that.
Yes.
I'm sorry, because the way we had estimated it, we had not anticipated that the Solicitor General would come and make arguments also. I mean, it's unanticipated.
Not beyond 12:30.
Yes, very well.
We start the other case at 12:30.
Very well. Now, if your lordships take my note,
Yes.
I've said that there are two conditions that follow. First page, third note. Condition 1, that the existence of a fundamental norm or basic feature that needs to be secured. Now, once the vacuum exists, it's not absolutely necessary that the court steps in to fill it. The court will step in to fill it. My Lord Justice Rastogi has that note. That 2 pages. 2 pages, yes. So the first condition that has to be filled is that there has to be a value, a fundamental norm, which exists here, at least 2 separate norms. The second is that the existence of the vacuum is having a grave effect on the rights of the public, either directly or indirectly. Lack of independence of the EC gravely affects democracy, such as the EC must be independent, just like the judiciary, like as your lordships have said in Scora. Absent both of these conditions, there may not be a felt need for the judiciary to intervene, as there could be several other vacuums in the constitution which could be left untouched. Other values which have to be applied, institutional integrity, which your lordships laid out in the CVC Thomas's case, an independent appointment mechanism, which your lordships have laid down in Vineet Narayan, a non-arbitrary process after the decision in Triple Talaq, where your lordships have used manifest arbitrariness as the test for laws. It has now been followed in about 22 cases. That test has come to stay. So now your lordships will examine whatever guidelines are being laid down, will ensure that there's no possible elbow room for such arbitrariness. On the right to give 5 copies, on that point, and I think it's important, your lordship may finally settle the law on the right to vote being a constitutional right. There is a very interesting article which I read many years ago, which I've annexed. It's at page 143.
Can you describe it as a right which is
A constitutional
being on the enactment of the constitution without reference
Absolutely.
to law being made?
Absolutely. In fact, Shubhankar Dam, whose article I've annexed.
That is one area,
Yes.
we may have a say that it's a real statute.
Correct. So the note I've handed up, the note I've handed up will show your lordships the entire history of how that concept has been discussed by the courts.
Oh, that's good.
And how it, from 2 judges, it got referred to 3 judges for a decision, after which stray observations in Kuldeep Nair and other judgments are all reconciled. And the position that continues today is that it's resoundingly a constitutional right. But there are two judgments which have put a question mark because they have come back. Two judge judgment. That's at item 10 and item 12. Both of them have, I think in passing, said it's a statutory right.
So it is three judges bench.
Two judge benches.
But when the PUCL is, 1213,
Said constitutional right.
NSCC page 1.
Correct, correct.
It is said statutory right.
It has said statutory right. So your lordship may consider those three. I put all of them here in this note. I am saying now, one argument with that Shubhankar Dam's article makes, it's published in Public Law. It's annexed in the at page 143 of that compilation I've given your lordships. I've referred to it at page 2. It says that if it were only a statutory right, then if your lordships were to just conceive of a situation when section 62 of the Representation of People Act, which gives the right to vote, if that were repealed, what would happen? Would democracy end in this country? And he expands on it much better than mine. So your lordship may just take a look at that article. Justice Chalameshwar's views and Shubhankar Dam's articles, I think, make a very strong argument for why it's very clearly a constitutional right. This question of prisoners, etc., is a reasonable restriction, like you have in fundamental rights. Reasonableness flows through the entire constitution. So even for a constitutional right, this will be a reasonable restriction which would be there. So it's very clearly, in my view, when 326 uses the word entitlement, it's an entitlement to anybody past the age of 18 to say, I have a right to vote. I don't have to look at section 62 for that. I get it from 326. Your lordship will take a look at that note. There's a comparative chart which is at page 4, dealing with all those South Asian constitutions, UK constitution, US constitution, to show how they have filled all those gaps which we have left unfilled. Your lordship may take a look at that. One important thing, which
where do you get
page 4 and 5 of the compilation of the spiral bound.
Okay.
4 and 5 of the spiral bound. I've put the page numbers in the note itself.
Oh.
I'm just drawing your lordship's attention to that. One important thing, yes. One important thing is they all put mandatory figures on the period of the election commissioner. They say 65 years. They give one single figure. Because you have a proviso in our case, there's a problem. If the proviso didn't exist, then compulsorily that man would have to get 6 years. If the proviso didn't exist, please consider that. I mean, we haven't challenged the proviso, none of us, but we should have. We should have to ensure that that independence remains. Now, the only avenue available is, your lordship will see it from our guidelines, is that whatever, when your lordship consider laying guidelines, your lordship may consider that there would be a minimum age which would be in consideration. For the trigger points, point number 6 in my note, trigger points, I've given a bunch of what I believe are the trigger points, one of which your lordships have taken judicial notice of. Statistically, 24% of all members of parliament in this country had criminal cases. 24% in 2004. That number we rose to 30% in 2009. We were proud to say in 2014 that it had become 34%. And now, my lords, it's at an all-time high of 43%. I'm hoping that in 2024, they don't disappoint us. So the problem, trigger point I'll explain is this, that I mentioned, my lords, from 2002 till now, how the Supreme Court stepped in and said, give affidavits, series of judgments, including that last judgment, which I referred to, Ram Babu Singh Thakur. I've annexed that, Ram Babu Singh Thakur, where a timeline was given and it was specifically said, please ensure that all the parties will disclose their antecedents while they're choosing these individuals, etc. If you fail to do so, it will be contempt of the Supreme Court, election commission to file affidavits. Have they filed?
We are on a different point. We don't want that.
I'm stitching something up.
That is not the issue before us.
No, I'm
It's not
sorry.
happening it.
Your lordship will not. I must explain what I'm trying to tell you. The election commission was asked by your lordships to file reports on it. Did they file reports? No, they didn't.
No, we did.
No, we did. We don't have any reports.
No, I'm sorry. I'll correct my friend.
Yes.
There is a direction by this honorable court, my lords, to file a report with a full compliance of the direction. And we've been doing it after every state legislative assembly election.
contempt.
Number one.
I'm saying
But
contempt.
because the contempt was, there was a, if I may say so, my lords,
Yes.
my friend will agree because he was also appearing in that matter. Because the contempt, the court gave a direction. It was only the work which was entrusted to the commission.
You have been doing it.
Fine. No, so the initiation of the contempt proceedings.
Just one thing.
Yes. Yes.
A whole lot more helpful.
If I compile it, in one.
Combine
I'll do
all your notes.
I'll do that. I'll do that, sir.
Otherwise, what will happen is we
No, no, I know.
for separate.
I know. So the spiral bind I'll leave as it is. The additional notes I'll compile.
Additional notes, put it in
Yes.
one. Then we can
Yes.
see.
Yes. All I was saying is that I still have three minutes more. I'm watching the clock and I'm going to finish. What I was saying on this point was only that the election commission, in my view, had to file a contempt petition here, which they haven't done. I feel there are trigger points and they feel pressure not to do it. There are 3 articles I've referred to. Please just, if your lordship don't mind, in this note, it's just not jot these page numbers down. If your lordship.
Winding it, you're giving it to us.
It's already there. I just want to
Not just put it in one form if you
just
can.
jot down the page numbers. I
Yeah.
just take 2.5 minutes.
Yeah.
The first article, pages 69, 77 to 79,
Yeah.
and 81 to 82
Yeah.
of the compilation. 69, 77 to 79, 81 to 82. The second one, 109. Third one, 117, 119, 120, and 124. These are very informative articles about how gaps in constitutional interpretation are filled up and how we have moved towards where judiciary fills it up. And this is not India. This is Canada, US, UK, everywhere.
That is important.
That's very important. You also may see that. There's also an article by me, which is at page 151, which is how I believe that the judiciary's strength, and this is a 2009 article. It's published in the SEC, but I put it at page 151. Your lordship may see that also. Now, one last thing, last 2 things. In electoral reforms, I've mentioned that there are a particular number of cases where the Supreme Court has stepped in and filled up gaps. Pages 125 to 137 in that spiral bound are the list of all of those where your lordships have repeatedly stepped in. The remedies sought, and I want to emphasize this for a minute. On appointment, I have suggested a procedure adopting the one for the Lokpal. These are possible guidelines I believe your lordships should lay down under 32-142. On the 3 other points that I argued, your lordship put it to them. I'm reminding your lordships that your lordship put it to them. They don't have an answer. They don't have an answer on the question of the protection to both ECs extending. Please make one note that protection to both ECs, reading that proviso in 324(5), they have given no response to it. They're accepting, in my view, the fact that the ECs will have the same protection as the CEC, as far as removal is concerned. In addition, something I just noticed, Section 6 and 8 of that 1991 Act ensures that both on retirement benefits pension as well as on conditions of service, it's the same for all of them. So the only aberration is a possible interpretation which says they don't have the same condition of removal. Independent Secretariat, page 7 of the Government of India's reply, they accept the fact that it is necessary, but they don't go ahead and implementing. Your lordship will consider this along with the consolidated fund drop.
May have,
Now that your lordship are
Your
having
lordship's
judgment in this matter,
Yes.
I just wanted to say, my lord, that the doctrine of lis
No.
pendens should apply to my interim application also. That same doctrine, meaning I had filed that application, brought to your lordship's notice, pointing out that
Doctrine of mispendence is a strict state, not a right to property.
Right.
No, I know it's not a right to property. I'm saying that the same principle, meaning that this particular appointment should abide by your lordship directions in this matter.
may
Her
have,
judgment was served.
may have just,
And Lord, we have handed over that whistleblower notification where the
Lordship,
preamble.
give me just,
are asking to keep it secret. Lordship, petition 3, we adopt secret. This one.
yeah, I wanted to go about this.
You can see the copy which has been given to us. Keep it see in our copy.
Original copy already done.
Original, we have given it back to you.
Your lordship,
We have given it back to you.
original act,
We have given it back to you.
Lordship, petitioner 3 will file written submissions, but 132nd point, 324, 4 and 5. Petitioner 3 will. 999.
You have never argued.
No, Milos Senior was arguing, but he's not available today. Just that short point, Milos, and we'll file the written submission. The point is about 324, 4, 5, and 6 on the vacuum and independence. There was the provision of appointing regional commissioners, which will also constitute part of EC. From 1951, hasn't been appointed. Rather, there has been assumption of role by Chief Electoral Officer, which was not envisaged by Constituent Assembly debates and even the.
Thank you.
Can I just half a second of your lordship's smile?
Half a second is okay.
Mr. Subhash Gardam is a good friend of mine. I know him fairly well.
Who's your
He written not only the article, written other articles also on several other issues, even issues regarding judicial legislation. I suppose there are some things to be pointed out there. I can always pick up something like this and show it to you. I'll place it on my That's why. As against the infallible arguments on the other side, I suppose I can have one final say. I have not, in the course of my arguments, addressed on the question as to whether a particular model, this or A, B, C, D model, is desirable or not desirable. I don't think the court even went into analyzing which will be the ideal model. No. Number one. Number two, therefore, the question of looking at other examples may not arise at all. Secondly, in each and every one of the cases cited, every one, from Veeraswamy onwards, there is always an immediate trigger point which is a matter of concern. Always. Always. So nothing happened in the abstract. And we were revisiting the question of judicial independence again and again and again. So that is a matter which invites our attention. That's the only thing that can be said. Therefore, there will be something which is left unsaid, something more said. We keep revisiting it. Therefore, can we say there is a gap? So that is a very abstract way of looking at it.
Do you have
That's all.
Do you carry home the impression that you have not placed your best as usual? You have put in you have done yours. We must thank all of you, all members of the bar. I mean, you have assisted us in the best possible way. So we just,
Most grateful. I was only glad I could assist you a lot.
we said that.
Right.
Assisted.
But these
You've done your karma.
documents which you have handed over,
Sorry?
those documents you handed over, which will remain with your lordship.
The copies.
That's
Copies will be with and we will preserve independence to the extent
I know that.
it may be necessary. We may have to refer to it. That's a different.
That's if it becomes necessary.
If
It becomes necessary. Because I thought your lordships are not getting into that question in it.
How much time for written notes? 3 days.
Your lordships, I thought you not be getting into that question in it.
Do you want to file a written notice about my brother?
Yes, we'll do that. We'll do.
Make a
But as far as this issue is concerned, it may not be necessary for
No, not for this issue. This issue we have understood what the position is. What my brother is asking you whether you want to give a competitive note, and my note is.
We will do that. I will do that. I will do that.
So then we'll say 5 days time.
That's right.
5 days time for all sides to give their brief written note.
On arguments, beyond arguments, not beyond what is argued.
What is argued of you? We don't have to. Within a 5 days, not exceeding 6 pages. Whenever we have said 3 pages, what we have found is the font becomes smaller.
We always have. Also, your lordships.
In fact, Justice Roy rightly pointed out, what happens at times is that what you argue, and when you file your written argument, my lords will find that there are some 6, 7 more grounds. New points. So I
mean, limited to what
has
is
to be restricted to what.
limited to what is
But by judgment, I said, quote, what was argued was something different.
limited to what is argued before the court.
It happened before justice.
Yes, then there-
Judgment you delivered. Kerala.
Fertility of mind.
argument was quite different. And when I look into the written submissions, they are quite different. I said, but the problem was, I had just since written down immediately after the closure of the submissions. So I have some completely fresh to recapitulate what was argued.
The council was that he underestimated the laws and he is very.
I'm only tempted to say, I'm sorry for saying that, only tempted to say, we're talking about speed. I mean, and somewhere there is something, or if you talk about speed, you comment on that without knowing how exactly it has happened. It is an incomplete comment. And we have cases where, when judgments are not written for 3 months, this honorable court says, then they will become non-est. Therefore, there is always a question of speed which depends upon the level at which our decisions are being made. Don't therefore
These are
these are very comments at a level where I think it's not.
In
It
cricket,
should not be made.
in cricket, fast bowlers depend on speed, batsmen depend on timing. In this appointment, they depend on both. I'm grateful.
So far as this constitution bench is concerned,
Yes.
so far as the entry of the judges, I am the opening batsman.
Keep your mind. Yes. Where? Yes, sir.
Item 502. In item 502, I have filed one application for framing additional issue. That application may first be taken.
But I think there's really nothing, my learned friend is giving.
Issues have
Let
been-
me.
issues have been
First of all, like you to sort of introduce yourself in the sense. Cases are for appearing.
There are 18.
And very beginning,
Yes,
say, we want to save time.
yes.
Each one of you will try and tell us what points you will sort of allocate to yourselves, what, because there's no point in repeating.
Lord, we have allocated.
We would
the-
request you so that.
Lord, we have divided the points between us. There are 5 councils that are appearing for the.
How many council? 5.
5 is what I think is there. Five for the petitioners.
5 for the petition.
Petitioners who have challenged that.
Okay.
And
Now
who
there
are
are 3. One is the Tamil Nadu Act. Then
Yes.
Karnataka.
and
Look, there are three, Maharashtra, Tamil Nadu, Karnataka. So one is going to be, Lord, I will seek to address on broadly on all
Now
three.
you, who are running for?
Lord, we are appearing for different parties, not petitioners.
Please.
Lord, see, Lord,
Give me-
I am appearing, Lord, in 2 writ petitions where the petitioners challenge the virus of the Tamil Nadu amendment to the PCA.
All right. So you are appearing for the petition.
Yes.
What about?
I-
I have, so, no, go.
Lord, I appear for the petitioners in a writ petition civil number 24 of 2016, Compassion Unlimited Plus PIPA. Then I'm appearing, all 3 statutes are under challenge. Then I appear in PETA, which is People for Ethical Treatment of Animals, writ petition civil 1059, and in a, which relates to the Maharashtra law, and a writ petition civil 1152, which relates to the Karnataka law.
So
All
you are
three.
three you are appearing.
Lordship,
Animal Welfare Board of India, that's the first petition. That in that the notification was under challenge of 2011. Then after the laws have been amended and presidential assent has been given. So all other petitions are challenging those amendments.
correct.
Therefore, let them begin first. I will assist my lords in as regard to whatever the Animal Welfare Board.
Then who is appearing for the state of Tamil Nadu?
So I'm appearing for PETA versus Tamil Nadu. So it's a challenge which is laid against the statute.
You are supporting them.
And
I'm appearing for the state of Tamil Nadu, Lord, then along with Mr. Rotaki and Mr. Sibal, Lord, there's 6 petitions filed against Tamil Nadu.
You know, we got the picture.
Yeah. Lord,
Tamil Nadu deals with the Jellikattu. Tamil Nadu deals with the Jellikattu, whether there is an earlier judgment of Nagara. Therefore, my Lord,
Then
there
you
is-
see what Bisbee is
Yes,
taking, right?
yes.
So let's, you start.
Yes.
Tamil Nadu can start.
Lordship, that application first needs to
What
be
is that?
taken.
What is that application?
That is IA number 17346 of 2020. In the writ petition 1188. This is item number 502.13. Let's just hand over the issues which.
There are 14 cases, isn't there?
Yes.
There are, my Lord, see.
There's one by court motion, RS, the last case, Ajay Marathi.
Yeah.
What is that?
That was a petition filed before Bombay High Court challenging the Maharashtra Act, which was transferred to this court by the Lordship. And this is a petition by the farmers for protection of their rights under Article 21 and 19(1)(g), right to livelihood and right to occupation. Yeah, this is the petition, Lord. And these are the three additional issues I am requesting for this honorable court to frame. And the first issue is about the whether challenge to the Prevention of Cruelty to Animals Act violates right to livelihood of farmers and people associated with bullock cart races guaranteed under Article 21 and right to occupation guaranteed under 19(1)(g) of the Constitution. That is first question. Second is,
Sachin,
yes, Lord.
let us get started. How is it, how the matters will coalesce? How they may arise? Let's see, because we are, as of now, we have to deal with the 5 issues. Maybe it will fall. We can't be at this point of time, expanding it without knowing what it is.
Let's see, order.
I can give a background of these issues.
We don't have to see, let us see.
Let's see, order of reference is precisely there. It only crystallizes the issues which have occurred to their lordships at their point of time.
We can't be expanding it beyond the scope of the welfare system.
No. That order itself says that apart from the other issues raised in the read, these are the following issues we are referring for the consideration.
Considering when the matters are.
Lordships may consider it as and when your lordships hear them and let your lordships.
Comments argument.
Correct,
We will not get anywhere.
I'm not saying go to the commencing of the argument.
Please let somebody.
Mr. Luthra,
I appear in that Ajay Marathi matter that your lordship mentioned. It is a matter from Maharashtra, where the validity of the Maharashtra Amendment Act 2017 was challenged.
Correct.
And there initially the interim relief was granted in our favor. The state of Maharashtra thereafter made an application praying for vacating that interim relief that was rejected, and then the SLP was filed. During the pendency of the SLP the Jalakattu matter came, and thereafter the transfer petition was filed, and that Maharashtra, our petition is also now transferred here. That is that serial number 0.14 in that 15 matters list. So I will be addressing your lordship so far as Maharashtra is.
Otherwise, we are wasting time on periphery.
I believe that since the questions have been framed in Jalakattu matter, I believe that Jalakattu matter should initially be thereafter Maharashtra.
Lord, if I may do all the introductions, we never get to.
Lord, if I may be permitted to start.
Yes, but I'll start. Yes,
Let's start. My friend, want some. Not I fight for IE number 11 or 216. I want delicate where was not who are organizing this function. But IE bear out not also. I'm supporting the government.
Hear you because it's a question of law basically. I mean, unless there is a mixed question of fact or something like what really happened.
I'm not going to the facts.
Very little. Disputed questions of facts.
That's right.
Facts are only for the purpose of crystallizing the issue so that your lordships can consider.
That's right.
Otherwise, these are pure questions.
We will hear all. I mean, those who are here before us, if something.
Any facts that are necessary,
like
your
Narayan wants to make his submission.
lordships will be approached here.
Only thing is that supposing some argument is raised by somebody,
Yes.
the court has understood it.
Yes.
Then nobody needs to repeat it.
No, it won't be repeated. From the side of the
That is how it
petition.
should be done. Otherwise,
Of course.
the whole idea of the constitutional bench is defeated.
Lord, we have done certain housekeeping, Lord, for ourselves. And therefore, Lord, Mr. Luthra will
That's
actually.
exactly what Brother Rishikesh Roy is concerned about, that we should organize it in such a way
No, we are doing that.
that, you will responsibly allocate the sort of work.
We have done it, Lord, we have done it our
Is it possible to kind of enumerate subject-wise? The arguments will be advancing, but then it can be divided.
Lord, once Mr. Luthra gives the introduction,
Yes.
thereafter, Lord, he sets out the points. We ourselves will
Because
not.
we have the reference 5 points,
Yes,
but on what would be the foundation of your argument?
yes.
It can be enumerated.
Lord, is it enough, Lord, if we give it at the time of commencement of the submission?
Yes.
So that, Lord, we stay within the 4 corners of what we are.
And also you can divide among yourself.
We have. Lord, we
Which
have.
points?
So that we have already made it.
Yes,
clear.
yes.
So please start.
Yes, I'm not the additional issue I made that when lordship will consider that
Which one?
the application which I made for framing of additional issue.
That's
Because once arguments are started,
you are
then
appearing for the petitioner or for the.
petitioner farmer for protection of farmers' rights under 21 and 19(1)(g).
That's a matter which has been referred to.
Is referred, that is item number 502.13.
When you argue your case will, somebody will be the respondent.
Yes,
So when we hear, we will decide as to whether it's a matter we will do. Whether it's completely beyond the scope of even the reference, we'll decide it. So let us not get stuck here, please.
I'm not, if I may just begin. Yes, of course, I will. I'm not, what has happened in this case, as your worship recalls, there is an order of 2nd of
So
August.
you are appearing in compassion.
Lord, I am appearing, Lord, yes, Lord, I'm appearing in 3 of these matters, that's the compilation is over. As I said, please take it, I'm appearing in writ petition civil 24 of 2016,
Then
1059 of 2017 and
1059.
1059 of 2017 and 1152 of 2018.
1052.
Yes, ma'am. Number,
now what are the prayers in
number,
that?
I'll just tell you.
What are the prayers in that?
But please take it, that in these 3 cases, I'll just tell you, Lordship, don't bother opening the file. In all these cases, Lord, there is a challenge to the Amendment Act by each state and the rules. So the challenge is there, the Amendment Act is there. I've called it out in the chart.
All that.
Lordship.
Okay.
The amending act will make it.
Follow.
Now, there are 5 questions framed, plus 3 additional questions which Maharashtra has framed. For your Lordship's convenience, I put them in a structure, which I'll just tender. Take it. And the proposal is to deal with it as thus. So, I'm sorry.
Take the prevention of cruelty to animals.
Yes,
That's the most important.
that's the act of the day, Lord.
Why you are here?
It's been part of volume 1 of the compilation, my lord.
But we'd like to have it,
Yes, of course.
All the rules.
Number, as I was saying, Lord, so there were 3 statutes, amending statutes by the states, and 3 sets of rules. Lord, unfortunately, I must point out that the Maharashtra statute could not be placed on the compilation. I'm carrying it. We'll tender it, Lord, in a moment. Now, please come to that structure of submissions. If my Lord just has this 1 pager I've given you.
Yeah.
So, Lord, the structure of submissions on, there were 5 queries raised by the earlier bench. 1 page, the bench. 1 pager. Not 1 pager, I've handed you 5 copies. I've given 5 copies. 1 page.
Just give that 1 page.
Yeah. I'm sorry.
Yes.
I thought I'll give copies to my friends later, but I'll give it. I hope you will. Number on the left side, I put down the questions that were raised by the bench, the referral bench. So my point is, in part 1 of the submissions, question 4.1, 4.2, 4.3, and N number is Maharashtra questions number 2 and 3 will be dealt with. This is part 1 of the submission that I propose to make, which is the jurisdiction issue in relation to legislative competence to enact the impugned acts, whether the acts fall in entry 15 list 2 or entry 17 list 3, are they colorable legislations, whether laws are laws protected under 29 cultural rights, and the effect of presidential assent and the challenge to it. Part 2 will be relatable to question 4.5, whether the legislations have been enacted to nullify the judgment in Nagaraj and review the judgment and the doctrine of separation of powers, which relates to question 4.5. And part 3 is the validity of the impugned legislations as tested in rights enumerated in part 3, directive principles, and part 4, duties. So that is relatable to Maharashtra number 1 and question 4.4, that's structured broadly. Now, I don't need to trouble your lordship with the questions. You've read the referral questions, so we will not go into that. just to point out the nature of the legislation under challenge. I've got to just hand over these copies. But does your lordship have these thin volumes are passed on? Thin volume. If my lords are kind enough, but the first page is the Maharashtra Act. I'm not going to trouble your lordship with that for a moment. Please just come to page number 4, just to tell your lordship what is under challenge. Yeah. So the in Tamil Nadu, it's the Prevention of Cruelty to Animals, Tamil Nadu Amendment Act 2017. It's document 137, that's Convenience Compilation Volume 1. D1 is Volume 1. For your lordship's convenience, I'll take you through that. Then below that, the rules framed of the Tamil Nadu Prevention of Cruelty to Animal Conduct Rules. These are under challenge. Document 16, 148. In Karnataka, middle column, Prevention of Cruelty to Animals, Karnataka, Second Amendment Act 2017, and below that the notification of 14 November 2017. Similarly, for Maharashtra is the 2017 Act, document 14, and then the draft rules, and then the Maharashtra Prevention of Cruelty to Animal Conduct Rules or bullock cart rate rules. Now, this is the extent of the challenge. For your lordship's convenience, we have also put down the relevant provisions at page 7 onwards. The comparative chart of the relevant provisions. The central statute is in the first column, then Karnataka, Tamil Nadu, and Maharashtra. Karnataka, Tamil Nadu, and Maharashtra at page 7. We'll get into that in a minute. Yeah. I'm not. Kindly just consider we are concerned with 3 sets of activities here. Essentially, there's an overlap. Jallikattu is a sport where a bull is released into a crowd of people, and there are men who then try and hang on to the lump into the back, try and control the bull, and the bull tries to escape, and this causes human injury, a lot of injury to the animals, and that was the subject matter of the consideration in Nagaraj. Then we have Kambala, which is annual buffalo races in Udupi and Dakshin Kannada districts of Karnataka in November to March. You have pairs of male water buffaloes which are tied together using nasal ropes, shafts, etc., yokes, and put in slush water, and depending on the category, jockeys may use ropes, whip sticks to make them run. So that's the second sport. The third sport will be Belgada Shariat or Chakdi or Shankarpat, various names in Maharashtra. Again, no person rides the cart. Bullocks are brought blindfolded, made to run, and they are put through a ghat with spectators on both sides. So the idea is to make them run under the effect of fear or probing or prodding. That's the situation in all these sports. There is a lot of material that we have placed, and if my lords are kind enough just to come to page 5 of that chart for a moment, of that note for a moment. There are certain reports depicting the nature of activity. Kindly just have a look at document 62 at page 1118 of volume 3, Convenience Compilation. Convenience Compilation, volume 3, page 1118. No, ma'am, Convenience Compilation is separate. Earlier.
What in?
Does your lordship have 1118? Document 61.
Page 1.
1118. 1118 is document number 62. Volume 3.
I have an objection with regard to
I have an objection with regard to the consideration of this has been trusted before a lordship by means of this compilation. Without any affidavit, certain comments have been made before photographs which are totally misleading, but there is no affidavit to support it. First time, my lord, then 5 days back we have received with all these 100 photographs. But they're all part of the petition, my learned friend, may not have been apprised. They were filed along with the petitioner's report. It's not that we have introduced them for the first time. They were filed with the petition.
Oh, they got it to 2022.
Sir, this, my lord may recall, the convenience compilation was prepared after it was determined between both sides that what is relevant for the purpose and which is in different files will be compiled together.
Actual things have to come by means of an affidavit, not like this without.
Otherwise, also on the basis of photographs, we can't decide the issue.
Yes.
But I must tell your lordship, there is going to be material in the nature of what is the nature of the sport and whether cruelty is being perpetrated. So I was just pointing out to your lordship, what is the nature of the sport on a visual basis, so you understand as an introductory issue. We'll get into the material and what constitutes cruelty or not in terms of the law in a moment. But I just wanted your lordship to see what is the activity that's carried out to make it clear.
What is the ground of the challenge? See, what
No, Lord, I tell your lordship.
we are dealing with
Yes.
the exercise of legislative power by the, say, the Tamil Nadu, Karnataka, and perhaps they are identical.
Yes.
Section 3 and 11 have been amended.
Yes.
Section 11, must be A to E was already there.
Yes, madam.
That is what was considered by the earlier Nagaraja.
Yes, madam.
It was found that in the case of Tamil Nadu, because they were having the 2009 Act, that was found to be repugnant.
Yes.
So the conviction of the Tamil Nadu state was, it was traceable to entries in the state list. That was repugnant.
Yes.
It was found that it come under entry 7
Yes.
of the concurrent list,
Yes.
namely prevention of cruelty to animals. Therefore, it is a subject which is be dealt with under the central law.
Yes.
So the provisions of the state act was found to be contrary to the central law.
So, Lord, I must tell your lordship.
So now we have a situation because it is in the concurrent list.
Yes.
The state legislature has actually amended the law.
Yes.
Now it may not be open to you to now contend
Yes.
that example 11(3)(f), which they have added in the case of Tamil Nadu,
Yes.
is contrary to section 11(a)(1).
No, Lord,
The scheme of the act appears to be the acts of cruelty which are prohibited are actually captured in section 11. Please don't do this, don't do that, don't
Yes.
do that. It's an offense, 10 rupees, 50 rupees, second offense, and all those things. Correct? Primarily.
No, Lord, I must tell your
Now,
lordship.
they have got rid of legislative, whether it's correct or not. The challenge can be only on grounds available to you when you challenge the law.
Yes, but that's the point.
So the first point you have is legislative competence.
Yes, but now the issue is this, and I'll tell your lordship how that becomes relevant. So the question really will be, and that is something your lordship will test. Can we, on legislative competence, they have tried to fit it into two buckets. On the one hand, they have chosen
Article 29.
Article 29 comes later.
Right.
On the one hand, what they say that this is relatable to list 3, and that's the reason they've gone for presidential assent. On the other hand, the old argument of list 2 has come back. So the argument, and that was the question, in fact, that was also framed, if my lord may just recall, the question was in this relation also. Now the point is, Lord, and that is the question 4.1.
They have legislative power.
Yes.
Even according to your case, the earlier round was, this is a matter which can only engage the attention of the legislature with reference to its powers available, traceable to entry 7 of this 3.
Yes. Yes.
The state has power. Parliament, the way to make it in consonance with the central law, get the assent of the president. Admittedly, I think president is given assent.
Lord,
Yes,
there's a slight issue, my
Lord,
lord. There's a slight issue, my lord.
1%.
But our case is, no, Lord, I'm really
Should
grateful.
not have many voices.
Yes, yes. Lord, our case is that it is a colorable piece of legislation because that's going to be our argument. And I'll tell your lordship, the point that we seek to make is presidential, it will not fall according to us within list 3. And even if the president's assent is given, they had to show material to say what was put before the president, whether the contours of Nagaraj, whether the issues at hand were placed, and what was the repugnance issue and why they went to presidential said nothing placed. We'll come to that later. The second issue is, can this at all be relatable to list 2, entry 14 or 15? Now, apart from the fact it's been dealt with Nagaraj, but you have 5 judges being, so it's all open to you. This is the argument that is also sought to be raised today by Maharashtra as question number 2. And that is the point they raised, and I'll read that for your lordship. Whether the Prevention of Cruelty to Animals Maharashtra Amendment Act is also referable excuse me, to entry 14 and 15 of list 2 of the 7th schedule to ensure preservation, protection, and improvement of indigenous stock of native breeds of bulls. So that is yes. Now the point not that we will seek to make for your lordship's consideration is this: that A, it is not relatable to entry 14. It cannot be. Or 15. Or 14 or 15 is all not available. List 2 is not available to you. Secondly, you have gone to list 3 and you have gone for president assent under 254 to get a legislation, which in a law for prevention of cruelty to perpetuate cruelty. And our case will be that this is a colorable piece of legislation, and that is the argument we are going to put forward in extenso when I open. These were just the preliminary facts that I was just placing for your lordship, because the point that was sought to be made for your lordship's consideration is this.
Amendment decriminalized the action. That is one of the concerns.
Yes, I'm sorry, Lord.
The amendment decriminalized the act.
Yes,
that is,
and Lord,
especially that is one of the
It says that it is not cruelty if certain conditions are followed.
Now, Lord, the point is, if something is inherently cruel and the findings in Nagaraj 1 and the review have reached finality in that sense on the findings of fact.
That's a different argument.
Lord, no, I was responding. No, Lord, I was responding to my Lord's query. I'm sorry. I was just responding to my Lord's query, Lord. So what we are saying is, Lord, that there is those findings have, I would say, remain untrammeled, and therefore we're going to build on that. That was what I was.
Not only one indulgence for you after my letter of February. Lord, we have asked for the records in respect of the presidential assent. That becomes crucial if we have invoked list 2. Lord, your lordship will call upon them to give the furnishers copies of it.
List 3.
There is no challenge in any petition to the presidential assent. You have to challenge the assent then.
No. We are challenging the act.
No such question is came. Before my learned friend starts, Madad, I'm sorry, I apologize for not being here. My part is going on, so if your lordships don't mind, Madad, that I may flit in and out, and I just want to seek your lordship's indulgence to allow me to do that. Madad, because my part is going on, I mean, going and coming, your lordship.
You are appearing with the state.
I'm appearing for Tamil Nadu.
He'll go.
I know, but I'm just seeking your lordship's permission, that's all.
That's all.
I'm deeply obliged.
That's no difficult.
Yes. But before I begin the post-afternoon session, but there are just 3 dates which may be relevant. Get a context of what happened. So after Nagaraj and review, the center came out with a notification on 7th January 2016. That is, gets stayed in writ petition civil 24 and others on 12th January 2016. That notification was in essence allowing the sports. And on 31st January 2017, the center which had moved an application,
31st January again,
2017.
1 year thereafter.
1 year thereafter, Lord, there is an order passed by your lordship in IA 16, which says that the center is withdrawing the notification.
Correct.
So, Lord, that's important because contemporaneous to that, you have, excuse me, contemporaneous to that, Lord, you will have these legislations and the rules which all come in January 17, July 17 and 18, November 17, I'm sorry. So not that's just to give your lordship a broad, just to give you some relevant dates, that's all. But if your lordship permits, before we start, I would like to read the referral questions unless I take it your lordship has read them.
You can read it. You read it.
I think
You
I
read it in your way.
Yes. But the referral order is produced at page 2250 of volume 5 of the convenience compilation, though it's a reported order. 2018, we've got a copy of it. 2018 to SCC 645.
2018?
To SCC 645. 2018 to SCC 645. It's also at document 74, page 2250. My lord, doesn't have it. I was just speaking.
That's all.
Yeah, please sit, Lord.
Page number 2.
Lord, 2250 at 2252. Yeah, I'm not. Present batch of writ petitions was originally filed to quash and set aside a notification issued by Union of India on 7th January 2016 and to direct the respondents to ensure compliance with this court's judgment reported as Animal Welfare Board of India versus A. Nagarajan, 2014, 7 SCC 547. However, while these writ petitions were pending, the Prevention of Cruelty to Animals Tamil Nadu Amendment Act 2017, which received the presidential assent on 31st January 2017, was passed. Writ petitions were then amended so as to include prayers to set aside the aforesaid Tamil Nadu Amendment Act on several grounds. After hearing the petitioners and respondents for some time, here is the view that these writ petitions need to be authoritatively decided by a constitution bench of 5 learned judges, as the writ petitions involve substantial questions relating to the interpretation of the Constitution of India. Questions which require reference to a bench of 5 learned judges, apart from other questions raised in the writ petitions, are set out herein below. 1. Is the Tamil Nadu Amendment Act referable in pith and substance to entry 17, list 3 of the 7th schedule to the Constitution of India? Or does it further and perpetuate cruelty to animals? And can it therefore be said to be a measure of prevention of cruelty to animals is it colorable legislation which does not relate to any entry in the state list or entry 17 of the concurrent list? 2. The Tamil Nadu Amendment Act states that it is to preserve the cultural heritage of the state of Tamil Nadu. Can the impugned Tamil Nadu Amendment Act be stated to be part of the cultural heritage of the people of Tamil Nadu so as to receive the protection of Article 29 of the Constitution of India? Is the Tamil Nadu Amendment Act in pith and substance to ensure the survival and well-being of the native breed of bulls? Is the act in pith and substance relatable to Article 48 of the Constitution? Does the Tamil Nadu Amendment Act go contrary to Article 51 AG and 51 AH? It should have been F and G, but it says G and H. And could it be said, therefore, to be unreasonable and violative of Articles 14 and 21 of the Constitution of India? Is the Tamil Nadu Amendment Act directly contrary to the judgment in A. Nagarajan, Supra, and the review judgment dated 16 November 2016 in the aforesaid case, and whether the defects pointed out in the aforesaid two judgments could be said to have been overcome by Tamil Nadu legislature by enacting the impugned Tamil Nadu Amendment Act? So these are the 5 questions framed. There are 3 questions which I said.
Mr. Luthra,
Yes.
let me put a question.
Yes, Lord.
According to you, these amendments,
Yes, Lord.
they are related to which legislative entry?
No, Lord, that's the point I was making. Lord, the entry, if at all, will apply, could have applied, would have been entry in list 17 in list 3. But that entry 17 in list 3, if at all. But entry 17 in list 3 relates to prevention of cruelty, not perpetrating of cruelty. Now, we are in a situation, they have gone to take presidential assent because it's list 3, but at the same time, they are invoking list 2 because they realize that they are dealing with creating of cruelty, not preventing of cruelty, and that's the whole purpose, and that is the reason I'm saying it's colorable, and that is the reason the question was also framed in terms of the Nagaraj.
That is the first question. That is the first question.
Yes, sir. Yes, sir. That's the question.
Mr. Luthra,
Yes.
if it is list 2,
Yes, sir.
And there is power.
then there is legislative power.
Yes, sir.
If it is relatable to list 3, then even that aspect stands cured.
Not on the curing of that aspect.
Why are we trying about which source of that power? Because in both counts,
But I'll give you one.
Unless you have a case, that it falls in list 1.
But my case is this. It does.
No, do you have a case that it falls in list 1?
But it's it's list 3. There is no case of list 1. Lord. We are not propounding that case because that is not the matter at all.
whether that's a matter of nomenclature. Many times the title of the act may not match with what is quoted in the act.
Yes, of course. Yes, of course.
The field of legislation,
But
entries,
that's-
as you know, broad fields of legislation, Article 245, 246 gives a power.
Yes.
245 gives a power, actually.
Yes.
That's the difference.
But we are not, I must make it very clear. It is nobody's case that it falls within list 1. That's not.
It doesn't fall in list 1.
Yes.
Because if it falls in any of the entries, it is a residual entry. So you don't have that case. So then, irrespective of whether it's list 2 or list 3, the argument based on legislative entry may not.
But
be
I'll
of
tell your lordship why. They seek to rely on, I appreciate what your lordship says, they seek to rely on list 2. Our point is, it is not list 2. And so far as list 3 is concerned, perpetration of cruelty, therefore you can't fit it in list 3, therefore you don't have competence to enact it. Secondly, Lord, therefore colorable. Secondly, the point.
That's why then it will fall in list 1.
Lord,
But you don't have a case that it's in list 1.
We're not saying it's in list 1. That's the point.
And I mean, that will be, neither here nor
I'll tell your lordship, I'm not, look at the Parent Act. Let's not look at the Amendment Act alone. Where does the Parent Act fall?
First of all, the prevention of cruelty to animals.
Yes, my lord.
To our understanding of what you
Yes, of course.
The title, of course, as you know, can always be pretty much misleading.
Indeed, my lord.
Capturing the entire detail by just having a look at it.
Indeed, my lord.
If you come to 11.3, A to E.
Yes, Lord. Lord.
For instance.
Yes, of course.
Now, when you say prevention of cruelty to animals, it is not an absolute idea. For example, it can go to the extent of destruction of stray dogs.
But there are 3 things which are acceptable. Science, stray animals or animals which are harmful, and thirdly, food for religious purposes.
In regard to them, cruelty as we understand it is permitted. Now, see, when you kill a stray dog, for example,
Yes.
you're extinguishing life of
Yes, no.
animal activity, because animal has been defined in a very broad way.
Yes, madam.
So, if the legislature thinks that if something should be added to that, then as to whether other grounds are available, we are keeping quiet.
Yes.
But when you say that the legislative entry is not there, it's
No, Lord, I'm on slightly different point. Let's look at, if your lordship looks at it, let's start with objects and reasons of the laws. Start with the statement of objects and reasons first. Let's open the act. Does your lordship have it?
we are only just telling you.
Raising an issue, not so it can be addressed.
When you are talking about legislative competence, deep matter, and you know the difference even in voidable, with the violation of fundamental rights and lack of legislative.
Yes,
it's still born. Okay.
Yes.
So if you say that it doesn't come under list one, very fairly you put it. Then legislative competence is there.
But the question is
as to whether it is contrary to Nagaraja. The attempted without taking away the basis for the judgment to undo the judgment.
But that's the separation. No, that's the third argument. That I'll deal with separately. That I'll deal with separately. No, that's the third argument. So if I may take your lordship straight away to the statement of objects and reasons.
Yeah.
I believe we have the same act, and if we do, it's at page 1.
Unnecessary pain, suffering.
But Mr. Vinupal tells me that their argument is going to be that it's list 1.
We haven't given you any ideas, people.
No, we have already considered that, Melons, and we will be submitting that there is no entry to which the statute is traceable either in list 3 or list 2.
So
it will be in
97.
97.
Then it goes into 97, in which case, Melons, there's no competence in the first place. Grateful, Melons. My apologies for interrupting. I just wanted to clarify to Mr. Luthra.
Thank you. But we have many players, not some right out, some left out, and some center. So I think my friend is playing the center. Now, Lord, please come straight away to that. Please consider the statement of objects and reasons. So the Committee for the Prevention of Cruelty to Animals appointed, as your lordship have it, page 1. Yeah. The Committee for Prevention of Cruelty to Animals appointed by the Government of India drew attention to a number of deficiencies in the Prevention of Cruelty to Animals Act 1890 and suggested a replacement by a more comprehensive act. But then they talk about the existing act in this scope. Leave one para and come to besides declaring certain type of cruelty to animals to be offences and providing necessary penalties for such offences and making some of the more serious of them cognizable, the bill also contains provisions for the establishment of an animal welfare board with the object of promoting measures for animal welfare. Provisions is also being made for the establishment of a committee to control experimentation on animals when the government, on the advice of the Animal Welfare Board, is satisfied that it is necessary to do so for preventing cruelty to animals during experimentation. Not whatever is even exempted is controlled. The bill also contains provisions for licensing and regulating the training and performance of animals for the purpose of entertainment to which the public are admitted through sale of tickets. The Prevention of Cruelty from that act having been passed, etc., came on the statute. Now come to the title word, an act to prevent the infliction of unnecessary pain or suffering on animals, and for that purpose to amend the law relating to the prevention of cruelty to animals. So the purpose is other than necessary pain. So you have to avoid all unnecessary pain. Now, therefore, those exemptions are carried out, and I'll come straight away. Now, Lord, the act in subsection 3 of section 1, when subsection 2, D says what is a domestic animal. Then please come to section 3. In your copy of the act, my lords will get the amendments that have been brought on by Karnataka, Maharashtra, Tamil Nadu, but we'll come to that later. State amendments, section 3. Duties of person having charge of animals. It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. Now, 4. Establishment of Animal Welfare Board of India for the promotion of animal welfare generally and for the purpose of protecting animals from being subjected to unnecessary pain or suffering in particular, there shall be established by the central government as soon as may be after the commencement of this act, a board to be called the Animal Welfare Board. And Lord, the functions of the board, of course, are there in section 9, Lord. Please come straight away to section 11. First the title in chapter 3 and then section 11. Cruelty to animals generally. Treating animals cruelly. If any person beats, kicks, overrides, overdrives, overloads, tortures or otherwise treats any animal so as to subject it to unnecessary pain or suffering, or causes or being the owner permits any animals to be so treated, or B is related to employment, C, willful administration of drugs, etc. Now please come to M for a moment straight. Solely with the view to providing entertainment, confines or causes to be confined any animal, including tying of an animal as a bait in a tiger or other sanctuary, so as to make it an object of prey for any other animal, or incites any animal to fight or bait any other animal. Or N, organizes, keeps, uses or acts in the management of any place for animal fighting or for the purpose of beating any animal, or permits or offers any place to be so used, or receives money for the admission of any other person to any place kept or used for any such purposes, or O, promotes or takes part in any shooting match or competition wherein animals are released from captivity for the purpose of such shooting, and then the punishment is provided. Now, what is exempted is, please note 3A, nothing in this section shall apply to the dehorning of cattle or castration or branding or nose roping of any animal in the prescribed manner. So there has to be prescription to how it's done. The destruction of stray dogs in lethal chambers or by such other methods as may be prescribed. The extermination or destruction of any animal under the authority of any law for the time being enforced. Any chapter dealt with in, any matter dealt with in chapter 4, or the commission or omission of any act in the course of destruction or the preparation of destruction of any animal as food for mankind, unless such destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. So the swan song of the legislation is avoid unnecessary pain or suffering. Now, Lord, what is excluded in your lordship?
We just test your argument,
Yes.
by a sort of
Yes, of course.
couple of questions. Supposing instead of Tamil Nadu or the other states bringing about the amendment,
Yes, sir.
supposing Parliament itself had added 11(1)(f) on its own to the Act.
Yes, sir.
That is one scenario.
Yes.
We will take it a little further. Supposing in the original enactment, like the amendment in the present form made by these three states had been incorporated, taking taking stock of the practices you have in these three, and they sort of in the cooperative effort, they said please exempt. So they exempted it. Parliament itself had exempted it at the time when it was originally made, 1960. Just asking you to imagine it.
Yes, because we are imagining.
And if you did imagine that, would you then say that Parliament had the power, authority under entry 7 of list 3?
Parliament.
Venugopal is not here. This question
Yes, of course. And I'll try and answer it as
if that were done, will you still say no? You have to still go and hunt for entry 97 and that it is not in list 3? I mean, will that not be carrying it too far?
But I don't think. Mr. Venugopal is here.
Yes, fortunately, we thought he had audited.
No, Lord, I'll answer that straight away, Lord. The first issue is, what was the purpose of the legislation? And therefore, can you have provisions which are destructive of the purpose? And what are the exceptions carved out? Now, Lord, just to tell your Lordship, when the Act was brought in, please see section 12 for a moment. As to the nature of practices that
So
were.
how do you answer our question? Supposing Parliament had amended it instead of, because Parliament has power not under Entry 7. Or will you say Parliament does not have power?
No, no, Parliament has power to amend it, but the question is not. The question that I'm raising to myself is this. Let's look at Entry 17 and what it says. Prevention. Now, can you perpetrate cruelty while preventing it? That, with respect, Lord, is something which I would submit even Parliament can't do, and that's the whole purpose. If my Lord just has noted that, specifically the entry is prevention of cruelty.
See, that becomes a legislative.
That would be perhaps
legislative value judgment. That becomes an area where you have to bear in mind the thin dividing line between the wisdom behind the statute and the legal, aspect about the statute.
Yes,
we are concerned not with the wisdom.
Yes,
if we were there, we would not make this law. It's a different matter.
That's
it. That doesn't permit us to sit in judgment over
absolutely not.
Sovereign power of the legislature.
Yes.
Whereas, if you say, for example, that it is manifestly arbitrary,
not in fact
after the line of judgments has opened up. After the Triple Talaq case, the McDowell case has been revisited, and now we have firmly sort of accepted that position. To say on the one hand that you are doing this for prevention, and you do precisely what is. Well, we are just
not a lot. I must tell your Lordship very candidly.
That's a different area. That will bring in a different test altogether. But to say that they don't have power is.
What I'm saying is this. The point that will be supplementarily made is that it is an issue where your Lordships have defined certain rights and 21 rights. Now, once those rights are defined, reading into that the fundamental duties and directive principles, even in
that's by a two-judge bench.
No, it is. But I'll tell you, Lordship.
Animals have Article 21 rights.
Yes, but there is the issue of personhood is there, and once there is personhood and there are rights, my submission would be to your Lordship is then the question is, how are you going to test this legislation on the anvil of
on a lighter note, if you don't mind?
Yes, of course, not at all. No? It's always.
My brother was. We were just contemplating that night has fallen, and we are in an area which is infested with mosquitoes.
Yes.
So supposing the mosquito is just about to land on you and take what it wants. A mosquito is also an animal.
Yes,
that's a very wide definition.
Yes, of course.
We were just wondering whether we will stand in fear of being convicted under this act, or whether we will do what might be necessary to protect ourselves, or be in a ward which deals with dengue. And we just
other issues.
We told you that don't take it either as
not at all.
Because we are also for the protection of the animals.
Yes, of course.
In a manner of speaking. Nobody. Because the Constitution commands us that we should have compassion. That is one of the articles which we are going to rely on. Nobody can say that we will not have compassion. We should have compassion for all living creatures, but it's always a vanity.
Indeed.
When you talk about intergenerational equity, when you talk about all the rights, it is always a balance.
Yes. Definitely.
So now the mosquito.
No, not so far.
How will you deal?
No, as I said, the Act itself provides, as would any legislation, of things which are accepted in relation to necessity and where the balancing has taken place within the legislation. That fine balance exists within the legislation. The question is to be tested is are these legislations part of that fine balance, or are they, as has fallen from your Lordships, completely arbitrary and completely having no rationale with the purpose of the Act?
Different argument.
Yes.
We should be clear in our mind what we are saying.
Yes, of course.
Legislative competence is one thing. after the law is made by competent legislature, whether it should have been made, are the three grounds, fundamental rights, any other part of the constitution violated? These are the two grounds.
Yes, of course. So we're coming to that part. I'll come to that part exactly. Meanwhile, Lord, can we defer the mosquito for a while?
Pardon?
Can we defer the mosquito? Put the mosquito.
Yeah, absolutely.
Yes.
And then mosquitoes are wise, fellas. They run away before they are spotted.
Snakes also. Snakes.
Snakes.
Snakes then. If you are going away from this mosquito, what about snakes? Snake.
Each one of us. Not snakes, your lordship will fall of a different legislation, the Wildlife Protection Act. There you will have more serious
Going
consequences.
by the definition of animal.
But there it is a more serious consequence.
Any living creature other than
No, I'm
the
telling
other
you,
real
lordship.
creature, that is
But there your lordship will have more serious consequences. Then you are running into the realm of the Wildlife Protection Act, where the consequences for the snake is much more serious. And that's a different frame, not to be placed today, but I can place that to your lordship from 39 onwards. Because I have some little understanding of that legislation. Lord, that's a very, very onerous legislation. There was a time, Lord, when I was on the dark side, when I used to be on the other side, but since then, my friends have converted me. So I have from my previous avatar an understanding of that law a bit. There, the way the law, at least in the Wildlife Protection Act, is in a forest, in a nature reserve, you cannot do anything to touch an animal. And the law is very stringent, right? In fact, that is to preserve wildlife, Lord, is something which we've amended that legislation. Till 72, we had state acts. Once we came into 1972, we had the central legislation. And then even for ivory, which is something which is not elephant ivory, but ivory of mammoth ivory, even that we have banned in this country. So that is a totally, as I said, different realm. So sometimes, Lord, one will have to run rather than touch the snake. So, Lord, if I may come back to that legislation, my Lord. Lord, you had put to me the issue regarding experimentation. Just keep two provisions in mind. Section 12, which even while holding an animal, a cow is a captive animal or a milk animal, it talks about certain practices which are not to be done. That's the level of sensitivity as the legislation originally contemplated, because there is, of course, there is a use for humans of cattle, and yet there is protection in section 12. So, my Lord, we just have a glance on, if any person performs upon any cow or other milch animal, the operation called Fuka or Doomdev, or any other operation, including injection of any substance to improve lactation which is injurious to the health of the animal, or permit such operation being performed upon any such animal in his possession or under his control, he shall be punishable with fine which may extend to 1,000 rupees, or with imprisonment for a term which may extend to 2 years, or with both, and the animal on which the operation was performed shall be forfeited to the government. 13 is, where the owner of any animal is convicted of offence under 11, it shall be lawful for the court, if the court is satisfied that it would be cruel to keep the animal alive, to direct that the animal be destroyed and assign the animal, and to assign the animal to any suitable person for that purpose, and the person to whom such animal is so assigned shall as soon as possible destroy such animal or cause such animal to be destroyed in his presence without unnecessary suffering and any reasonable expense incurred in destroying the animal. And then, Lord, there are provisions, etc., where animals are injured. Now, these exceptions in the Act, there are certain exceptions in the Act which you will find, Lord, in the sense in section 13 for destruction. Then chapter 4, which is very important. Experimentation on animals. Nothing contained in this Act shall render unlawful the performance of experiments, including experiments involving operations on animals for the purpose of advancement by new discovery of physiological knowledge or knowledge, which will be useful for saving or for prolonging life or alleviating suffering or for combating any disease whether of human beings, animals, or plants. 15. Committee for control and supervision of experimentation. So there's a committee. 15A, there's a subcommittee, then there's the staff. The duty of the committees are pointed out in section 17 in extenso, and subsection 2 is important. In particular, and without prejudice to the generality of the foregoing powers, rules made by the committee shall be designed to secure the following objects, namely, that in cases where experiments are performed in any institution, the responsibility thereof is placed on the person in charge of the institution, and that in cases where experiments are performed outside an institution by individuals are qualified in that behalf, and the experiments are performed on their full responsibility. Then experiments are performed with due care and humanity, etc., anesthetics, etc. I won't trouble your lordship with that. 19 is important. Part to prohibit experiments on animals if the committee is satisfied on the report of any officer or other person made to it as a result of any inspection under section 18 or otherwise, that the rules made by it under 17 are not being complied with, or any person or institution carrying on experiments on animals, the committee may, after giving an opportunity to the person or institution of being heard in the matter, by order prohibit the person or institution from carrying on any such experiments, either for a specified period or indefinitely, or may allow the person or institution to carry on such experiments subject to such conditions as the committee may think fit to impose. And then there are penalties to be imposed. Chapter 5 is very important, Lord, and this is crucial. Please keep one factor in mind. In 2011, the government came out with a notification exempting bulls as performing animals. That still continues till date. So on the one hand, we have the central government notification saying bulls are not performing animals. We have Nagaraj, and on the other hand, we have these legislations and their subsidiary rules and regulations. Now, please, 21 is training and exhibition, but come to 22. Restriction on exhibition and training of performing animals. No person shall exhibit or train any performing animal unless he is registered in accordance with the provisions of this chapter as a performing animal, any animal which the central government may by notification specify as an animal which shall not be exhibited or trained as a performing animal. And then not these states have come out, the 3 states have already come out with their amendments, basically to take out Kambala, Jallikattu, etc. Same, and that's a challenge. Now, there are offenses in 26. Not, please come to 28. 28, 27 first and 28. Nothing contained in this chapter shall apply to the training of animals for bona fide military or police purposes or the exhibition of any animals so trained, any animals kept in any zoological garden or by any society or association which has for its principal object the exhibition of animals for educational or scientific purposes. 28. Saving as respects manner of killing prescribed by religion, nothing contained in this act shall render it an offense to kill any animal in a manner required by the religion of any community. Now, not here again, they brought in 28A, 28A, all 3 of them have brought it there again. And my lord, there is 38. 38. So 38 provides for rules to be brought out, and that's the power of the central government.
Exception for domestic pet. Because they are also kept confined.
Yes, but that's domestic pets are in 2D.
That is what domestic animal.
Yes, not so. Domestic animals means any animal which is tamed or which has been or is been sufficiently tamed to serve some purpose for the use of man, or which, though it has neither been nor is intended to be so tamed, has in fact become wholly or partly tamed. So that's the provision for
training of domestic animals. Is there an exemption?
But I'll just 11. But I'm not what the The restriction is if my lord just comes to 11 for a moment,
Yes, yes. Okay.
E, keeping in a cage, F, chained or tethered, G, being the owner neglects to be exercised reasonably, H, not giving food, I, abandoning the animal, etc. Is so every animal will be covered with mutilation, etc. Not you, even domestic animals, pets are protected or covered. I'm not 38 is the power to make rules by the central government, as I was saying. Now, what the states have done is, Maharashtra at least, they've introduced 38B, saying that we have the power to make rules. So these are the issues under challenge before your lordship. While you're looking at the legislation, please also look at page number 21. These are the draught animals rules. And kindly just look at page 23. There is a maximum load prescribed. There's number of passengers that can be put in. There are conditions for the number of hours, etc., that they have to be used. The temperature where they have to be kept. How they have to be disengaged after work. And 8 is most important. Use of spiked bits prohibited. No person shall, for the purpose of driving or riding an animal or causing it to draw any vehicle or for otherwise controlling it, use any spiked stick or bit, harness or yoke, spikes, knobs or projections, or any other sharp tackle or equipment which causes or is likely to cause bruises, swellings, abrasions, or severe pain to the animal. My lord, we also come back to the definition. So large 2A, large bullocks, large buffaloes are covered under these rules. Here. Now, Lord, there are also livestock market rules and transportation rules. The transport of animals on foot rules are there, which we.
That is not very relevant.
No, Lord, they will be relevant which will be applied to these animals, and I'll tell your lordship why. Lord, if my lord is kind enough to see, that relates to cattle specifically. So these are rules relating to cattle. Lord, they will be just. Lord, they will just. 139 are the livestock market rules. Just have a look at that first. 139 of that volume of that same act. Is your lordship at 139? Please note in 2D, calf means a bovine animal under the age of 6 months. E, cattle means a bovine animal including bulls, bullocks, cows, buffaloes, steers, heifers, and calves. Note which is at 144 as to what are the practices that are harmful and cruel which are prohibited.
Context of the livestock, the market.
Livestock, not, and then there are transportation of food rules also. I don't want to trouble your lordship necessary with all this. Sorry, my learned friends also want me to point out one two things. Just kindly just see 14 for a moment at 145. Does your lordship have G? Forcing animals to perform any unnatural acts such as dancing, putting any ornaments or decorative materials on animals. And 15(2) C. 15(2) C. It shall be the duty of the person in charge of an animal in an animal market to ensure that animal is not or is not likely to be caused injury or unnecessary pain or suffering by reason of C. The animal being hit or prodded by any instrument or other thing, nose ropes or nose peg or bits are pulled, yanked and jerked, causing immeasurable pain and suffering or any other cause.
Not in the context of a market, animal market.
Not so even in a market, the point is not.
Market cannot be done. This is what the rules say.
Yes, Lord. So all these, Lord, the whole purpose is that cattle for animals, even in the marketplace, even on foot, there are various sets of rules which exist in the Act, and all of them deal specifically also with cattle. So cattle are included. I don't want to necessarily go into it. Just not keep one note on my note. Document 6, my Lord, which is like note of that. I won't trouble your lordship with it. Document 6. Those are at page 55, first volume. These are the transport of animals on foot rules. And at rule 11, they prohibit the use of whips, sticks, etc. to hasten the place of the walk of an animal. As I said not earlier, we have the performing animals registration rules, of which those are exempted. The 2011 notification is still in force.
Which is performing section 21.
Yes, but 21.
Is it on the basis of sale tickets? Are they doing it on the basis of,
But the argument today is being raised is that there is a commercial aspect to this.
So if you read the definition of exhibit and train.
Yes, Lord.
In section 21.
Yes. In this chapter, 21, Lord.
Yes.
In this chapter, exhibit means exhibit at any entertainment to which the public are admitted through sale of tickets, and train means train for the purpose of any such exhibition, and the expression exhibitor and trainer have corresponding.
And section 22 is connected with 21.
Yes.
So
22 is connected.
The most important aspect about it is that it should be for our public are admitted through sale of tickets. Without that being there, it will not come within the scope of exhibit or train, because training is for the purpose of exhibition.
But even, Lord, I must tell your lordship, the way it's been read is that the activity itself of training or of putting an animal through training, one part is the commercial gain, but even if there is no commercial
sale of tickets, whether you are having a case that when these Jallikattu, etc., take place, they actually sell tickets and then people are invited to.
But in fact,
alone that is attractive.
Yes, Lord. So not the
performing animal, no, that is actually defined under performing animal rules.
Yes, my Lord. Yes, my Lord.
There, of course, if the public are admitted through sale of tickets.
Yes, Lord. Not
then they will.
Only then it comes.
It is defined.
Not in fact, not the notification that was issued. So there are two parts, as your lordship rightly noted. So exhibit and train is defined, and it says no person shall exhibit or train any performing animal as unless it is registered as a performing animal. Any animal which the central government may by notification of the Gazette specifies an animal which shall not be exhibited or trained as a performing animal.
The words train or exhibit, unless that happens,
yes,
22 doesn't kick in.
Yes, Lord. So now in this case, Lord, there is an exception created by the center, with the center through rules that cattle, bulls and cows are exempted from this 22. They are not performing animals. And I'll show that.
And the expression performing animal, that is defined.
Yes.
It's defined under the rules.
Yes. We'll just come to that.
At page 29.
Yes.
What exactly is the performing animal?
Yes, my lord. It says performing animal means an animal which is used at or for the purpose of any entertainment, including a film or an equine event to which the public are admitted. So not that's performing animal.
Admitted through sale of tickets.
It means an animal which is used for the purpose of any entertainment. Not
To which?
now. Not it only says entertainment now.
No, page number 29, rules.
I'm coming to that. Oh, I'm sorry. Lord, your lordship is a different. Yes, my lord, your lordship is saying performing animal. Yes, what means any animal which is used at or for the purpose of any entertainment to which the public are admitted through the sale of tickets. So, but your lordship is reading the rules of 1973. I was reading the rules of 2001, which are at page 25, document 3. Please have a look at that instead. The registration rules. Please have a look at the registration rules at page 25, first volume, document 3.
Document 3, yes.
Page 25, sir.
Is it here?
Convenience.
Volume 1 is here. Page 25, volume 1.
Does your lordship have the 2001 registration rules? Good. Lord, these are the 2001 registration rules. Here the definition is each performing animal means an animal which is used at for the purpose of any entertainment, including a film or an equine event to which the public are admitted. And here again, Rule 8 at page 26 has the general conditions and overleaf. At page 27, condition number 5 is relatable to inflicting unnecessary pain or suffering. 6 is feeding to compel to perform any trick. 7 is training an animal to act in accordance with its basic natural instinct. It should be not 8 should be pregnant animals or injured animals or sick animals. And 9, of course, is loud noises. And 11 is not to injure them. 14 is again not to give them in proximity of loud sounds. And 15 is important, that props such as spears, nails, splinters, barbed wires, and such others shall not cause injury to the animal during performance.
Mr. Luthra, something,
yes,
something
of course.
different.
Yes, of course.
Little digression.
Yes, of course.
Just find out these performing animals.
Yes, sir.
Now, I happen to be associated with the production of a documentary.
Yes, of course.
Now, as a producer, you are required to give a certificate that during the film we have not caused any harm or injury to any animal. Now, where does that requirement flow from? Because that is needed for censorship.
Yes, Lord, it is not. That is required, Lord. That would be under Lord the Censorship Act.
Cinematography Act or censorship.
But you say show it to me. But may I just
You are supposed to
Rule 7.
The producer is
Lord, Rule 7. Rule 7 is here, Lord. Rule 7 is this. Prior information for use of performing animals in films.
Now, this is required even if the animal has no, the film has no animals at all,
yes,
except human.
Yes. Yes, Lord. Indeed, Lord. Rule 7. Prior information for use of performing animals in films, every owner desire of hiring or out or lending a performing animal in the making of a film shall give prior information in the format as specified by prescribed authority for this purpose of specifying the kind of animal, age, physical health, and the nature of performance to be done, the duration of which animal shall be used for such performance, duration, and method of training of the animal for such performance, and justification for the use of such animal in the film, and such other information as may be required by that authority. And then it has.
Anyway, this may not be. Anyway,
but this is by the owner.
We are
This is by the owner. Yes.
We are digressing. That would be perhaps Cinematography Act or something like that.
Yes, but that would be Cinematographic Act. Not, and if I may just point out, 13 is most important at page 29. Prohibition on exhibition and training of specified performing animals. Performing animals whose performance has been prohibited under subsection 2 of section 22 of the Act shall not be trained, exhibited, or trained or exhibited as a performing animal. Now, Lord, there is a notification in this regard, which is at page 181, volume 1. This was considered in the convenience compilation.
Page 181.
Yeah. Lord, if your Lordship has that, this is the 11 July 2011 notification in exercise of the powers conferred by Section 22 of the Prevention of Cruelty to Animals Act and in supersession of the notification of Government of India and the erstwhile Ministry of Social Justice dated 14th October 98, except and as respect things done or omitted to be done before such supersession, the central government hereby specifies that the following animals shall not be exhibited or trained as performing animals with effect from the date of publication of this notification, namely bears, monkeys, tigers, panthers, lions, and wolves.
So that requires, I think, the realization of money through sale of tickets.
But
otherwise, that's the underlying idea.
But may I just point out, under 22,
for starters,
not under 22, once there is the restriction and they are taken out, 22.2, because there's a notification which allows you to, also there are two parts. It has to be a performing animal. If it is a performing animal, then you come to 21 as to the purpose for which it's used. But when 22 says certain animals are not to be performing animals, then there's no question of 21. That's the point I was making. And that is the reason 22.2 is very clear. It says, no person shall train or exhibit as a performing animal any animal which the central government may by notification the official gazette specify as an animal which shall not be exhibited or trained. 22
there is no exhibition if there is no sale of tickets.
Lord, if I may say so, Lord, there are two parts.
Supposing, for example, let's give an example. Supposing there is no sale of tickets.
Yes.
People in the village, they get together. Somebody has an animal and they all get together. There is no money realized. Just giving hypothetical.
Yes, of course, no.
But the animal is being exhibited.
Yes,
it's also performed.
Yes, of course.
Will it attract 21 and 22?
Now, Lord, here I may point out what your Lordships, Lord, there's a matter which came up through the Kerala High Court, lot of NR case which reached the Supreme Court. There they have specified that it is not only for commercial gain tickets, but even otherwise. And I'll just place that. That's in the case compilation 484. It's not page number 484, volume 11. Judgment compilation. Today is today. Volume 1.
Which page you want?
But this will begin at 484. That's the division bench judgment which traveled to this court.
Volume 2.
484, volume 1, judgments, volume 1 judgments. 484.
Not that. Change this to this.
Right. And if your lordship is kind enough to come to para number 7.
Yeah.
At 495.
Yeah.
Does your lordship have this?
Yes.
Yes. The petitioners have a further contention.
Yes.
The petitioners have a further contention that the impugned 495. The petitioners have a further contention that the impugned notification is arbitrary as it prohibits training and exhibition of animals only when the public are invited through sale of tickets as specified in section 21 of the Act, whereas it does not prohibit training and exhibition of animals where the public can be admitted without sale of tickets. We are afraid we cannot give our stamp of approval to this contention for the following reasons. Chapter 5 of the Act deals with performing animals. Section 21 defines the word exhibit to mean exhibited at any entertainment to which the public are invited through sale of tickets. Thus, persons who exhibit animals against sale of tickets are covered under this chapter, and those persons who choose to exhibit animals without sale of tickets would fall under section 11 of chapter 3 of the Act, subclause A of subsection 1 of section 11 of the Act, makes it an offense if any person beats, kicks, drives, overloads, tortures, or otherwise treats any animal so as to subject it to unnecessary pain or suffering, cause or being the owner permits an animal to be so treated. Once the exhibition of the specified animals is prohibited under subsection 2 of section 22 of the Act on the ground of prevention of infliction of unnecessary pain or suffering by the circus, the same yardstick would have to be applied in the case of a person who exhibits or trains animals for a show where the public is invited without the sale of tickets. So, Lord, that's the principle that was laid down by the Honorable High Court. This matter did travel to this court. And that's at page 499. Next judgment. And if your lordships are kind enough to see, Lord, para 8 will refer to the preamble of the Act. 21 and 22 culled out. Page 502. But there was a notification under 1991 where bears, monkeys, etc. were not to be traded. Now, 7 is the thrust of the argument. And I just read it at 502. The main thrust of arguments of the learned counsel for appellants has been that apart from section 22, the notification itself is arbitrary. it has been contended that 22 contains no guidelines on the basis of which the central government can issue a notification banning exhibition and training of any animal. It is also the case of the appellants that Act does not provide for the animals to be taken away by the government once such a notification is issued. The preamble of the Act states that it was enacted with a view to prevent the infliction of unnecessary pain or suffering on animals, and for that the purpose to amend the law relating to prevention of cruelty to animals. Section 11 provides as to what amounts to cruelty to animals generally, and what section 21, 22, 24 are quoted. Para 10. It will be seen that according to section 24, if it is proved to the satisfaction of the magistrate on a complaint being filed that there is any training or exhibition of performing animals which is accompanied by unnecessary pain or suffering, then court has jurisdiction to order the same. To our mind, keeping the preamble of the Act and 24 in view, power under 22 can be exercised only when the central government is of the opinion that training and exhibition of animals in respect of which a notification is being issued for the purpose of preventing unnecessary pain or suffering be caused. In the very nature of things, when animals are used for performance in a circus that requires their training, it is for the government to decide on the basis of evidence and record, and after taking into consideration other factors, whether training and exhibition of those animals would result in unnecessary pain or suffering being inflicted on them. It is pertinent to note that even with respect to animals whose exhibition and training is prohibited, the Act does not prevent the owner from keeping them as domestic pets. Of course, it is going to be difficult to expect someone to have a lion or tiger as a pet. That apart, it is the welfare of animals which is of paramount consideration, and it is only if the government is satisfied on the basis of material on record that unnecessary pain or suffering is inflicted on an animal during the course of training or at any time when it is exhibited, that a notification under 22(2) is issued. We are therefore not able to agree. So now that's the principle that was laid down. So it's not just commercial gain, but even otherwise than commercial gain is how your lordships have looked at it. Now, Lord, we have taken you through the provisions of the Act. May I just take you now through the provisions of the amending Acts? Please come to, we can go to the Acts by itself, but we culled it out of that chart I give your lordship, the compilation, page 7. Order. But this is the bunch that I gave you a lordship in the morning. Not compilation. That's the one I believe your lordship has in
Impugned amendments.
Yes. Comparative chart of impugned amendments, page 7. Page 7. It's put horizontally. My friends have put mine still vertically, but your lordships have put horizontally for ease. Now, please see the amendments plot. Let's go through them one by one. First, the Karnataka Amendment. Section 2AA, bull races or bullock cart race means any form of bull's race, including race of bullock cart, as a traditional sport. So the focus is on tradition, involving bulls, whether tied to a cart with the help of a wooden yoke or not, in whatever name called, normally held as a part of tradition and culture in the state on such days and places as may be notified by the state government. 2DD. Kambala means the tradition, sports, event involving buffaloes, male race, normally held as part of tradition and culture in the state on such days and places as may be notified by the state government. Now, Lord, these are introduced in the central statute, all of this, definition clause. Then look below that, section 3, duties of persons having charge of animals. It shall be the duty of every person having the charge or charge of any animal to take all reasonable measures overly to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. 2 is added. Notwithstanding, in the one bold, anything contained in subsection 1, conduct of Kambala or bull's race or bullock cart race shall be permitted subject to condition that no unnecessary pain or suffering is caused to the animals by the person in charge of that animal used to conduct Kambala or bull's race or bullock cart race, as the case may be, and subject to such other conditions as may be specified by the state government by notification. I'm not overly, if your lordship. Now, section 11 is on the next page, but the amendment is at page 10.
You are saying that nothing will apply.
Lord, yes, now conduct of Kambala. Lord, just see page 10. There. Page 10. Man. F and G have been added.
That's
the conduct of Kambala with a view to follow and promote tradition and culture, ensure preservation of native breed of buffaloes and also their safety, security, and well-being. The conduct of bull races or bullock cart race with a view to follow and promote tradition and culture and ensure preservation of native breed of cattle, as also their safety, security, and well-being. An overleaf lot at page section 22 at page 11, bold portion proviso to 2, provided that nothing contained in this section shall apply to conduct of Kambala or bull's race or bullock cart race, as the case may be. So in effect, Lord, what you're doing is you're nullifying the notification in which is under 22.2. It's complete destruction of that. And then Lord, overleaf. Section 27 is at the bottom, Lord. Overleaf. C and D have been added. Conduct of Kambala with a view to follow and promote tradition and culture and ensure survival of and continuance of native breed of buffaloes. Conduct of bull's race or bullock cart race. Conduct of bull's race or bullock cart race with a view to follow and promote tradition and culture and ensure survival. For 13, 28A has been added, which says savings in respect of Kambala or bull's race or bullock cart race. Nothing contained in this act shall apply to Kambala or bull's race or bullock cart race conducted to follow and promote tradition and culture. Such conduct of Kambala, bulls or bull's race or bullock cart race shall not be an offence under the act. But similar are the other statutes. The only difference, main difference will be that in the right column at page 13 bottom, Maharashtra has introduced 38B, which allows them to bring in rules. That's quoted at the bottom. That's the real distinction. Otherwise, in essence, they're all same, Lord. Some language change, but really the essence is the same, and the principles they choose to rely upon are the same. So the proposition that we are going to put to your lordship is this. We have the benefit of Nagaraj. If your lordship permits, I will only put the salient paras of Nagaraj and the review. Our submission is all these 3 state amendments do not either deal with or prevent cruelty, and they are in the face of Nagaraj, which I will deal with, of course, at a later stage, and they contradict and are destructive of the main objects of the principal central act. In our compilation, we have put down
bit of a pagination.
No.
So I've just asked him to clarify.
In our compilation note, we have put down certain cases which have preceded Nagaraj on animals and compassion towards them, and subsequent judgments which have followed Nagaraj. That I will give your lordship a list of cases. There are by various high courts. Some have sought to expand the principle. Some had followed it, so that I will give separately, but I don't want to trouble you right now with that. Let us just come straight to Nagaraj Puram.
Compulsion, volume 5.
In the convenience compilation earlier given, document 75, volume 5, page 2256.
It is already there.
No, it's there. The SCC copy is there, not at 2256.
Why should we have the SEC is much more.
Yes, of course. No, it's 2014, 7 SCC 547. 2014, 7 SCC 547. We've given a list of books also. But it'll be more convenient to have the book, not buy bulk it up.
You said.
I'll just tell your lordship.
Paragraph.
Nagraj considers
The other act.
the notification of 11 July 2011 banning the use of bulls as performing animals, which I placed. It deals with the Tamil Nadu Regulation Act of Jallikattu Law 2009. And then there were certain petitions from the Bombay.
It was found to be repugnant.
Yes, please. No, but there is more. There is just repugnancy was one of the aspects. I'm going to show your lordship what else. Won't trouble your lordship too much with the basic issues, but please come straight away to para number 15. My lord will note at para 13, the argument for Tamil Nadu was noted.
If you don't mind, just come to paragraph 91 where the directions are set.
Yes, of course.
And then you can do so that we
Yes.
have a better idea.
Yes.
Para 91.
Yes, Lord. 91, Lord. 91 will begin at not it said internal page 601 of the report. We therefore make the following declarations and directions. But 90 actually.
90.
We therefore hold that Animal Welfare Board of India is right in its stand that Jallikattu, bullock cart race and such events per se violate section 3, 11(1)(a), 11(1)(m)(2) of the PC Act, and hence we uphold the notification dated 11 July 2011 issued by the central government. That's the performing animals regulation notification. Consequently, bulls cannot be used as performing animals either for Jallikattu events or bullock cart races in the state of Tamil Nadu, Maharashtra, or elsewhere in the country. We therefore make the following declarations and directions. We declare that the rights guaranteed to the bulls under 3 and 11 of the PC Act, read with 51 AG and H of the Constitution, cannot be taken away or curtailed except under sections 11(3) and 28 of the PC Act. 91.2. We declare the 5 freedoms referred to earlier be read into section 3 and 11 of the PC Act be protected and safeguarded by the state, central governments, union territory, in short the governments, MOEF and AWBI. AWBI and governments are directed to take appropriate steps to see that persons in charge or care of animals take reasonable measures to ensure the well-being of animals. AWBI and the governments are directed to take steps to prevent the infliction of unnecessary pain or suffering on the animals, since their rights have been statutorily protected under 3 and 11 of the PC Act. AWBI is also directed to ensure that rulings of 11(1)(m)(2) are scrupulously followed, meaning thereby that person in charge or care of the animal shall not incite any animal to fight against a human being or other animal or another animal. AWBI and the governments would also see that even in cases where 11(3) is involved, the animals be not put to unnecessary pain and suffering, and adequate and scientific methods be adopted to achieve the same. AWBI and government should take steps to impart education in relation to human treatments of animals in accordance with 90 and inculcating the spirit of 51 AG and H. Parliament is expected to make proper amendment of the PC Act to provide an effective deterrent
to achieve the object and purpose of the Act, and for purpose of 11, adequate penalties and punishments should be imposed. Parliament, as it is expected, would elevate the rights of animals to that of constitutional rights, as done by many of the countries around the world, so as to protect their dignity and honor. Government would see if the provisions of PC Act and declarations and directions issued by this court are not properly and effectively complied with, disciplinary action be taken against the erring officials so that the purpose and object of the PC Act would be achieved. The TNRJ Act is found repugnant to the PC Act, which is a welfare legislation, hence held constitutionally void, being violative of 254(1) of the Constitution of India. AWBI is directed to take effective and speedy intents to implement the provisions of the PC Act in consultation with SPC and make periodical reports to the government. And if any violation is noticed, government should take steps to remedy the same, including appropriate follow-up action. So, not these were the directions issued in this judgment. Now, let us just come.
May also read para 86.
Yes, of course.
Or rather, you can begin with 84. The reason why we say this is the fabric, the text on the basis of which the court consider the matter has been altered.
Yes.
By the amendment read with the rules will have to be decided with reference to what fell for consideration there.
Indeed.
Paragraph 84,
Yes.
85, and 86.
Yes, but I was just going to say, Lord, my Lord may just see. Lord, just see 83 as well. 83 as well.
Yeah.
Section 38 of the PC Act, because there are rules have been made, confers rule-making powers on central government, and in exercise of the rule-making powers, central government made the Performing Animals Rules 1973 and the Performing Animals Registration Rules 2001. And thrust of all the substantive and procedural provisions is welfare and well-being of the animal and the duties and obligations of persons who are in charge of the animals, and also to safeguard the rights of the animals. Section 8(7) specifically refers to animals' basic natural instinct and cautions that the basic natural instinct of animals be protected and be not exploited. 84. The TNRJ Act is an anthropocentric legislation enacted not for the welfare of the animals, unlike the PC Act, which is an ecocentric legislation enacted to ensure the well-being and welfare of the animals and to prevent unnecessary pain or suffering of the animals. The State Act basically safeguards the interest of organizers and spectators while conducting the event of Jallikattu. The Act has no preamble, and the statement of objects of reasons of the Act reads as follows. And then, Lord, statement of objects and reasons. Jallikattu includes Manju Viratu, Urmadu, Vadamadu, or Erudu, Vidum Visa. The said function consists of taming of bulls as a part of ancient cultural tradition of the Tamils. The tradition is in vogue for more than 400 years. At present, there is no legislation to conduct the.
86.
Yes, 86. Section 4 deals with the responsibility of the organizer. Section 4(3) provides for double barricade area in order to avoid injuries to spectators and bystanders. The prime consideration is therefore to avoid injuries to spectators and bystanders and not that of the animal. Section 4(4) deals with the fixing of galleries for the spectators to sit and watch the event. 4(6) empowers the animal husbandry department to test the bills to ensure that performance and mass-bin drugs are not administered. Duties have also been assigned to the district collector under Section 5 to ensure safety of spectators and to see that bulls are free from diseases, not intoxicated, or administered with any substance like nicotine, cocaine to make them more aggressive and ferocious. Section 5, 9, and 10 authorize district collector to give wide publicity to the provisions of the PC Act and the rules made thereunder, and to ensure the presence of animal welfare activists of AWBI during the conduct of the event. Section 7 deals with penalty. It says, whoever contravenes the provisions of this Act shall on conviction be punishable with imprisonment, which may extend to 1 year, or with fine, or with which may extend to 10,000 rupees or more. 11 of the Act, it may be noted, provides for punishment of a term which may extend to 3 months. To that extent, there is inconsistency. I'm not. 87, I'll read. Yes,
87,
I'll read them. 87.
Finally, the court finds that there is a repugnance.
Yes,
That act was repugnant.
Yes, my lord. In 89, 89 is that finding that is repugnant. Now, my lord, what it says and what is more important is, and please note 88. 88 is a very crucial precursor to 89. 88 says the PCA Act, especially Section 3, coupled with Section 11(1)(m)(2), as already stated, makes an offense if any person solely with a view to provide entertainment incites any animal to fight. Fight can be with an animal or a human being. Section 5 of the TNRJ Act envisages a fight between a bull and bull tamers. That is, the bull tamer is to fight with the bull and tame it. Such fight is prohibited under 11(1)(m)(2) of the PC Act, read with 3 of the Act. Hence, there is inconsistency. But then, in para 89, I want to read that plot. The TNRJ Act in its object and reason speaks of ancient culture and tradition and also safety of animal participants and spectators. PCA was enacted at a time when it was noticed that in order to reach maximum gains, animals were being exploited by human beings by using coercive methods and inflicting unnecessary pain. The PCA Act was therefore passed to prevent infliction of unnecessary pain or suffering and for the well-being and welfare of animals and to preserve the natural instinct. Overpowering the performing animal was never in the contemplation of the PC Act. In fact, under 3 of the Act, a statutory duty has been cast on the person who is in charge or care of the animal to ensure the well-being of such animal and to prevent infliction on the animal of unnecessary pain or suffering. PC Act therefore casts not only duties on human beings, but also corresponding rights on animals, which is being taken away by the State Act, the TNRJ Act, by conferring rights on organizers and bull tamers to conduct Jallikattu, which is inconsistent and in direct collision with 3, 11(1)(a), 11(1)(m)(2), and 22 of the PC Act, with 51 AG and H of the Constitution, and hence repugnant to the PC Act, which is welfare legislation declared unconstitutional and violent. Now, Lord, there are therefore 2 parts. One is, as your Lordship rightly said, the repugnancy part. The other is that it's completely in collision with the object of the Principal Act. And there is no difference between, in that sense, between what was done by the TNRJ Act and what is now sought to be achieved.
So that
by,
you have to see a little bit about the rules which have
Yes,
been put in place.
Yes, Lord. I'm going to show the rules. I'll show your Lordship the rules as well, Lord. But I must also point out, Lord, this, what is important in this is not twofold. Kindly just make a note of certain other paras which may be of some relevance to your Lordship in this judgment.
Just as an aside, we just want to ask you one
Yes.
question so that you can.
Yes, of course.
It's about cruelty.
Yes.
No, cruelty to animals is sought to be prevented.
Yes.
That is the whole thing. Animals are our sort of friends, brothers, whatever we call it, part of. They have the same rights as we have. Correct?
Yes.
So much so that cruelty in the matter of sport, the matter of entertainment, is sought to be prohibited. Take a case where you have a boxing bout, or you have fencing.
Yes, Lord.
So you know what it means.
But I used to practice judo, Lord, I'm aware, at a serious level. So I'm very well aware. Though, I must tell your Lordship, judo is known as the gentle way.
Near you.
But it's okay. But then,
Assessing Griffith.
not, as I said, I did, not now.
Good thing that you told us.
But that was in my past. Different avatar.
Same distance.
Different avatar, Lord. That avatar is over.
Coming back to boxing.
Yes.
You know how they are
I'm aware, Lord.
pain, they die even inside this. So animals, at least you can say human beings can be treated on par with animals. So what do you say to that?
Lord, choice and lack of choice. That's the difference.
No, but many choice we are also controlling.
But I must
Suppose
tell,
somebody is getting
I must tell your Lordship.
intoxicating psychopathic substances. So that choice we regulate.
Yes. Yes, we do, Lord. But I must tell your Lordship, in the sports ring, and I can tell your Lordship from personal experience, one of the peculiar things that at least in the sport of judo is choking somebody by shutting off the blood supply to the brain, which is one way to get an opponent out. And you blank out. You actually blank out and it happens. And it just has to be done at the right level
you don't actually stop the breath. You don't, but it's only stopping the blood supply for a moment.
Oxygen goes.
And you blank out and you come back in a moment, you're revived in a moment. But when you enter any sport willfully, it may even be the sport of, as my sport is, let's say,
kickboxing,
not even squash. The possibility of injury exists, but you've taken a conscious choice of doing that. Adventure sports, of course, is another category altogether, but it's a question of informed choice. And that's what sets us apart of the sports we choose to indulge in. Fencing being one of them, non-fencing, they often have those tips at the end so people don't get stabbed too much. But that's really.
So the animals can't make a choice.
Yes, sir.
So can they have liberty?
The issue is this. Liberty.
He asked the question.
I'll answer
definite purpose. Article 21 speaks about no person shall be deprived of his life or liberty, save in accordance with the procedure established by law. So if you say that animals have no way, because their brains are not as,
No. There's a slight distinction. The point I was trying to make out is not that liberty is inherent. Liberty is inherent in every living being, whether it be any form of life. That liberty is inherent. And that is not something that is recognized by the Constitution. It's not given to us, but it's something which is inherent in all of us.
Can an animal?
Yes, no.
For example, we'll just start with the example with my daughter. Does the mosquito have liberty?
But of course,
not. The meaning of Article 21.
I would say not. Even the
mosquito. We're sorry about the mosquito. Actually, we have nothing against it except that it attacks.
But if one lives in Delhi, it becomes an issue that one is worried about mosquitoes all the time.
We are from Kochi, so
the issue is this.
Perhaps closer home might be polo, where the horse. The game of polo is a closer home to the analogies which they get injured, the horses.
Take, for example, horse racing.
Yes, horse
racing. The issue is
horse racing. You think the horses enjoy it?
But the distinction is, and here I say, we are dealing
elephant race. Kerala.
But we are dealing with. I'm sorry? But on the elephant race, I must tell your lordship that's pending another bench, not that matters likely to come up. It's in fact listed next month. So the issue is not when we are dealing with the fight or flight response of an animal, of a creature. So when we are inducing fear or inducing fight or flight, then that inherently is cruel. The difference is it's not that animals will not fight with each other. There are occasions when, just a minute. There are occasions not when we will find animals even in the wild, which choose even elephants, tuskers, you will find that they are battling things out. But here is a question where we as human beings are pushing them to exhibit a certain reaction to stimuli, which at the least can be said to be extremely cruel.
That is
for our entertainment.
For our benefit.
For our entertainment. You are stressing on that.
Indeed, no, that's absolutely right.
That is where we'll have to see the rules.
Yes.
We want you to see the rules because.
But I'll come to the rules.
What is the change that will be brought about in the
I'll take your lordship to the rules. All right, Lord. I was just.
That immediately take us to what.
Lord, I'll take your lordship to the rules straight away.
Yes. Let us see what they have.
Yes, of course. I'll take you to the rules and I'll come back to. Then what I will do is not at a later stage. Certain paras of Nagraj will be illustrated. I'll do that.
Let's see the rules.
Yes, of course, ma'am. The rules are placed for your lordship's consideration in volume 1 of the convenience compilation. Does your lordship have it?
Yeah.
But this is the abstract at page 148.
Volume 1. Volume 5.
Rules are at 150. 148 first note. Let's have a look at the
Volume 1.
abstract.
It's volume 1.
Volume 1, volume.
So let us see the page 150.
Yes, no. I just want to place note that first para. Does your Lord, does my Lord Justice Bose have it? Yes. Page 148, not document 16. Does your Lordship have it? Not? First paragraph. The Prevention of Cruelty to Animals Act was enacted to prevent the infliction of unnecessary cruelty and suffering on animals. The Act also recognized the need to exempt the application of its provisions in certain circumstances. The Honorable Supreme Court of India, in its judgment in Animal Welfare Board of India versus Nagaraj Civil Appeal, has found that the conduct of Jallikattu is violated to the provisions of the Central Act of 1960, particularly sections 311 and 22 of the Act. Considering the vital role played by the event of Jallikattu in preserving and promoting tradition and culture among people in large parts of the state of Tamil Nadu, and also considering the vital role in Jallikattu in ensuring survival and continuance of native breeds of bulls, the government of Tamil Nadu had decided to exempt the conduct of Jallikattu from the provisions of the Central Act. Accordingly, the government have decided to amend the Act. I'm not just pause here for a moment before we go into page 150. Please keep in mind that this is the same argument that was raised, tested in Nagaraj 1 and in the review. Not exactly the same propositions were examined. Nothing new about it. Now, please come to 150. There's the short note. Please see, under subsection 2 of section 3 of the Prevention of Cruelty to Animals Act, as amended by the Prevention of Cruelty to Animals Tamil Nadu Ordinance, the Government of Tamil Nadu makes the rule, not these rules were made under the ordinance, then under the Act. Now, please see 3. Any individual, organization, or group herein called as organizers intending to conduct Jallikattu in such places and on such days as may be notified by the government under clause DD of section 2 of the Prevention of Cruelty to Animals Act shall inform in writing to the collector of the district. Organizers shall also obtain prior permission from the collector for the persons as well as their bulls for participating in the Jallikattu event. The collector shall ensure that the names and other particulars of participants in Jallikattu are registered. Then Note 3 talks about inspection. 4 talks about having a committee of revenue, animal husbandry. Interestingly, not comprising of officials of revenue, animal husbandry, police and health departments to oversee and monitor conduct and ensure it's conducted in conformity with the rules. 5. The organizers shall ensure that bulls are put to proper test by the authorities of the animal husbandry department and that no performance enhancement drugs, irritants, etc. are administered to the bulls in any form. The collector shall, with the assistance of experts of the animal husbandry department, ensure that bulls are free from any diseases and not intoxicated or administered with substance with the object of making them more aggressive or ferocious. All of this is really not to facilitate the human element when humans come into contact with the animals. 7. E is the rest. B is in the holding area. Each bull shall be provided adequate space to exhibit normal behavior. Each bull shall be provided a minimum space of 60 square feet. Adequate feed and water shall be provided to the bulls and they shall be allowed to perform their normal physiological functions. The owner of the bull shall always be by the side of the bulls to assure psychological safety and security. Bulls shall be under constant monitoring of veterans of the animal husbandry department, police personnel to ensure the safety, security, and well-being of bulls. T. Bulls shall be thoroughly observed for any physical injuries to the body parts like mutilated ears, fractured tail, etc. by veterinarians of the animal husbandry department. If any injury is found, they shall not be permitted to participate in the event and be sent back. Then not what? Not 4 is examination of the bulls. Bulls shall be compulsorily subjected to veterinary examination by qualified veterinarians of the animal husbandry department. Participating bulls shall be examined for general health conditions by chemical examination. Bulls showing symptoms of fatigue, dehydration, restlessness shall be identified and not permitted to participate further in the event. The bulls shall be specifically examined for possible alcohol abuse, and any animal which is subject to such abuse shall not be permitted to participate in the event. The bull shall be taken to the entry point from where the nose rope shall be undone by the owner, and the bull is let inside the arena. The bull examination area shall be provided with roofing shamiana so as to protect the bulls from rain or sunlight. Arena shall be a 50 square meter area. Bulls have to be embraced. I like the use of the word not embraced. I grown up in a village, not only when they are domesticated are they embraced, not when they are aggressive or in the ring. Embraced by the participants within this 50 square meter area, the participants shall not be permitted to stand in front of the bulls. As they enter the arena, they should also not be permitted to block the exit way for the bulls. Participants shall be permitted to embrace the bulls by their arm and run along with the bulls for 15 meters or 30 seconds or sustain 3 jumps of the bull. Participants shall not hold on to the tail, horns using their hands or restrict the movements of the bulls by holding onto the bull's leg. The participants violating these guidelines shall be liable to be debarred from participating further in the event. 15-meter area shall be liberally strewn with carpet for cushioning effect to prevent any injuries to the bulls or participants.
Ultimately, granting exemption to Jallikattu.
I'm sorry, Lord?
Granting exemption to this local festival of Jallikattu. They put certain restrictions in the rules, how this has to be implemented and how you have to formulate for the benefit. So that balancing is there. The local festival should also be there. At the same time, there should not be any injury to any animal and whatever the precautions can be taken care of with the reasonable restrictions.
But in fact, that's the reason I had started by desiring to show to your lordship the way it is done visually. Visually, not the way it is done with that limited area for an animal of that size and with the nature of, let us say, embracing, to use the word of the rules. The embracing is such which is going to lead and has to lead to brutalizing and injuries. That is inherent in the manner, not where an animal is playing and you're trying to hold on to it and restrain its movement aggressively. Now, not all of this is very well to say tails will not be injured, tails will not be broken, you will not pull it, and you will only be allowed 3 jumps, you will not block the area. But the reality is that there are animal fatalities, there are injuries to animals, there are human fatalities, and every year after year, there are reports to that issue, reports to that effect, but the numbers have risen of the injuries caused both to animals and to humans. So that is the fundamental problem, Lord, with this. And the reason is this. But festivities and cultural festivals are one thing. But cultural festivities, assuming that they are cultural, assuming that we are going to elevate them, because that is something they will have to establish, that it is elevated to a cultural right. That is something which they are now seeking to raise. It was raised and rejected in the earlier round. Now again it's been sought to be raised in round 2 of the earlier, in the supersession of the earlier round. But having said that, the question really is going to be, can we allow even cultural rights or norms or practices which are contrary to part 3? Can we allow things which are abhorrent to what the constitution holds? Can we allow things which are going to bring about cruelty? Because I was recalling not this morning when I was talking to my friend that wonderful passage in Sachidanand Pandey, Lord 1987, my Lord Justice Chinnappa Reddy's wonderful decision where he says, what does respect for environment or respect for animal life mean to a human being? And that is a very telling passage on how those who live in nature relate to nature, not with brutality. So that's the whole purpose. And when your lordship sees, not This is what I would call glossing over the act of what is happening. These glosses will not take away from the inherent nature of the activity. And when you release this animal into an area where there are going to be people who are trying to hold on to it, what else is there going to be but flight or fight? It is going to resist being held or resist being controlled. And that is exactly, your lordship said not to get into the visual.
That's why you have put all those photographs.
But that's the reason to show you what the sport is. Not under the rules, what is the sport that is being carried out? We are not going to and I'm not going to get into this issue of anecdotal material. But if you see the sport, it visually the impact, it's very clear as to what's happening in terms of the size, the space, and these are 2022 photographs. Illustratively, Lord, just look at lordship on a lighter note. Every day when I leave my office at 8 o'clock, I feel like one of these animals because my juniors are trying to catch hold of me for that last question or that last instruction. So I can tell your lordship at that stage at 8:39 when I'm trying to run, it is a flight response. I don't dare fight with them because I have to keep them in good humor, but it is definitely a flight response where I keep telling them, I said, maybe I have a home to go to, can I leave now? And it doesn't often happen. Now, not just look illustratively as to what it is. Nothing else. Just look at volume 3, page document 62-1118, just two visuals. No, I'm not going to show you numbers, anything. Convenience compilation, volume 3. Just to get an understanding of what this is about and the kind of situation we are dealing with in general. Please look at page 1122. Volume 3, convenience compilation given earlier, 1122. But at some stage, I would suggest not that when your lordship has these wonderful screens, we should also have the ability of a screen can be put to show the document on the screen in color, because I think the copies your lordship will have is black and white, whereas because I have a soft copy, I have a colored copy. So 1122, the bull is at the back, not between those two pillars, so to speak, and is being brought out from the inner area. Don't bother reading the comments because my learned friend Mr. Dwivedi took an objection to the comments. I don't want your lordship to read it. Just see what happens.
Ideally, this photograph should be supported by an affidavit.
But this is part of the petition. This is part of the petitions that are filed. I'm not giving your lordship anything. I can show you from the writ petitions. Lord, there's no difficulty. Just show it on the writ petition.
No, that's okay.
Petition was filed in 2017 and this is of 22. How can it be part of petition?
Sir, we are allowed to file additional applications and affidavits, sir. So it's part of that. Please take it from me. I wouldn't want to get into something. So look at 1122, Lord. Then look at 123. There's a sharp object which is being used to control the bull's action. 1124. There is at the bottom a gentleman with a raised hand. 1125, the crowds. Well, I can. Though not the other day, the Honorable the Chief Justice said, if you give your iPad, you may not get it back, but I'm happy to pass it on for your lordship to see.
Hopefully you are safe.
But I prefaced by saying I used to practice judo. But this is the color photograph. I'm sorry. 1122.
Testing of positive. The same thing.
But same thing, 1122, 1123, 1124.
That's right.
And 1127. 1127. To 8. So this lot is the sport, which is
Now, under the rules, they cannot catch the tail, they have to embrace.
So why don't you?
not, it's like it's like the traffic rules of Delhi, where as we lawyers are not supposed to use our mobile phones, we are not to cut red lights, we are not to rush to reach the court for 10:30 mentioning. So not all those are wonderful rules on paper, but the reality is
we cannot approach challenge to constitutional.
Yes, of course.
Rules should be breached.
No, that's not the approach. But since your lordship put it to me on a lighter note,
Question is whether after the safeguards in the 2009 Act, whether there is a substantial change brought about in the rules. That's why a comparison with the Act.
I'll show your lordship straight away.
We'll have to place it side by side. Has it taken away the basic fabric basis for the earlier judgment?
But that
This
they
is
have
what we
not.
have to do.
But that they have not. And I can make that good straight away. Today we give the Tamil
So
Nadu.
looks like, is there any precedent like this in the US, the rodeo and cowboy or Spanish bullfight? Is there any?
European
Who's his president, Lord?
European court might have dealt with it.
Regarding bullfighting, there are cases, but
Not there was
hold of the judgment itself. They normally
in
like
Spain there is
Spanish languages. So there's Supreme Court of Spain law that releases in English the gist of it. That we have, but that we can't.
So my learned friend, Lord, I concur, Lord. There was a ban placed by the government in one region of Spain. Now the Supreme Court has allowed it in one region of Spain.
Catalonia.
Yes, Catalonia. We don't have the copy of the judgment.
So
We will
they
look
have
for,
allowed wherever it is linked with cultural
we will,
traditions, then they allow it.
Lord, we will look for American precedents
Minus
because it is, sorry, sir. We look for American precedents because it may be possible that there should be American
That is
precedents.
the rodeo with that
Yes,
news.
yes, rodeo with the news, not, and not there's bullfighting in Mexico, there's also, Brazil, my friends tell me it's illegal as well. Brazil, it is illegal, Brazil. But we'll give your lordship precedence as to what is the judicial treatment, if we can locate that and trace it. Not an issue. But this is so far.
Reason why I'm sorry for interruption. The reason why I was not objecting to the filing of these photos without affidavit, I learned some fresh petition has been filed in 22 with which the IA has been filed in this, but that apart, Lordship. I have no objection if Lordship permits them to place it. The point that the objection is for this reason. That now they show, Lord, there is a somebody holding a spike.
Metal sickle.
But Lordships would have noticed that the spike is upwards, not downwards, other way around. The sharp edge is inside. Why it is there, Lord, when the bull comes in, then the nose rope, what he does is the man, he cuts that. We have some, Lord, videos of that. And if your Lordship will permit, Lord, it can be seen that every time a bull comes, then they put it and they snap it and then it goes into the arena. Now, the trick of the photo is that when they are touching that rope, you take the photo like this and mention that somebody is nudging here. That's the title given. That's the Lord, unfairness to the court.
I'm sorry, Lord.
If the bull is sitting, they will say photographs show sitting. They will say it's exhausted, Lord, suddenly and it's sitting down.
I mean,
it's better to show the video itself, Lord, and then see, Lord, how it is being conducted.
Lord, there's no difficulty, Lord.
On behalf of the AWBI, we would also like to place the reports which are there of the last 2 days.
See,
But
in
Prime Minister,
the event it is in breach of rules, then it's always open to prosecute.
yes.
And this is of single instances. These photographs cannot represent all the exhibitions or whatever.
1 lakh,
Not the only idea
11,000 full
If you can
participated.
establish that this is the order
Lord, if I may
and
just,
everywhere the rules are breached, maybe one.
Lord, may I just.
1,11,000, lots more than that, the bulls have participated. Now these few photographs, they rather prove, Lord, that
So we are, we are being invited to interfere with the right of the bull to participate.
Yes, Lord. Now, Lord, if I may just point out, I don't want your lordship to get into, I think my learned friend in saying that there was unfairness to the court was unfair to us because what I said was, we do not want your lordship to get into the contents of those reports. I'm not troubling you, only to show you a visual depiction of what is the nature of the sport. And that one photograph to which my learned friend took exception is not the relevant point. What is the relevant point is that when they are released into that 50-meter pen with a 15-meter span so to run, there are people climbing over the animal and there is going to be, if nothing else, not pain and suffering being caused. And if your lordship, and I'll place that older legislation, what I will do for convenience on the other next day is, I will place a comparison of the new rules and the old rules, and it'll seem absolutely similar.
You are right. You can examine this change of with the amendments made.
Yes, Lord.
The change of rules, how they demonstrated. How they demonstrated. But there is one thing. If your 5-6 volumes convert into a convenience volume,
yes,
and you go on adding to certain more volumes,
Lord.
God knows
Lord,
what is the term of using a convenience volume.
Lord, I must tell your lordship, but sometimes for us, but what happens is sometimes the
There will be an act called Prevention of Cruelty to Judges.
But I was going to.
Like you spoke about cruelty to senior advocates, but juniors.
I'm going to say that not amounting to cruelty to advocates also. No, I don't think Mr. Grover. No, Mr. Grover, it's 4 o'clock. Mr. Grover, it's cruelty to the juniors who have to carry the files, not you and me. No, we should be fair. I avoid that,
But I was,
not using a laptop.
Mr. Grover, I was remembering a more gentle animal.
Yes,
and some of you might remember. The animal is named the Empress of Blendings.
Yes.
Does it ring a bell in
Yes, of course.
The
Yes, of course.
PG Woodhouse.
Yes, PG Woodhouse.
Lord Emsworth,
Yes,
the animal who is exhibited. But perhaps not ticketed. I was looking into the Nair judgment of Kerala High Court and which came here.
In fact, Lord, on exhibition, about 3-4 years ago, I was in Lord Pushkar. Coincidentally, at the time of the Mela.
Camel.
Not just camels, bro. They had this bull buffalo. It was so huge that we were all looking like pygmies before it. So one was concerned as to what had been fed to the animal and what had been done. It was huge. It was absolutely.
There used to be in Shonpur also in Bihar.
Shonpur Mela, not Shonpur Mela.
Around this time of the
Yes,
year.
Lord. Yes, Lord. Shonpur Mela is there, definitely.
But now with the
This is the international.
data and marketing rules.
The international there. People from outside the
From
country.
where not?
In this place. Pushkar.
Pushkar not because horses. Because all the.
No, it's the international festival.
International festival. Not,
People
it's
all
a great tourist attraction.
It's an attraction over there.
Yes.
I have not visited that time.
And so Lord, we continue on Tuesday then?
Yes. Tuesday.
Tuesday. No. I think the boy.